There we go. Webinar is now streaming. Okay. Good morning. This is the Board of Standards and Appeals, New York City Board of Standards and Appeals review session for December 5th, 2022. There is no public testimony during the review session. The first items up are adjournments. Item number 1, 12997BZ. Item number 2, 16755BZ. I'm sorry, let me go back to 12997BZ, 15065 Cross Island Parkway, Queens. Item number 2, 16755BZ, 20-65 Clintonville Street, Queens. Item number 3, 18285BZ, 209-11 20th Street, Brooklyn. Item number 4, 18385BZ, 206 8 20th Street, Brooklyn. Item number 5 is 2020 91A, 109 52 54th Avenue in Queens. The following is an adjournment. Item number 6, 2019 256BZ, 1508 Avenue Z, Brooklyn. The following are deferrals. Item number 7, 12992BZ, 150-55 Cross Island Parkway, Queens. Item number 8, 2021 87BZ, 3716 Union Street, Queens. And the followings are withdrawals. Item number 9. Hold on a second, I gotta get the sheet. Item number 9 is 201 97BZ, 11902 Rockaway Boulevard, Queens.
All right. This is a motion to withdraw without prejudice.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Oh, do that again.
Aye.
Okay. And Commissioner Yoon.
Aye.
Okay. Application is withdrawn. Item number 10, 2016 4249BZ, 2420 Amsterdam Avenue, Manhattan.
There's also an application to withdraw without prejudice. Make a motion.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Item number, the application is withdrawn. Item number 11, 2020 45BZ and 127 15BZ, 135-35 Northern Boulevard, Queens.
Okay. This is also, should we call both of them together or should we call them
I did.
separately?
I did, Vice Chair.
Oh, you did. Oh, I'm sorry. I didn't hear you then. There's also a motion to withdraw without prejudice.
Right. So you want me to call Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta. I'm sorry, can you hear me? Sorry, I'm on the, I'm pushing on the side. Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Commissioner Shabeta, you get like a little, some kind of interference there, but I can still hear you. So this application is withdrawn. Okay. Postponements. Item number 12, 31953BZ, 1135 East 222nd Street. Item number 13, 29557BZ, 14615 Union Turnpike, Queens. And item number 14, 2019-96A through 2019-155A, Blue Belt Loop, Cole Street, Staten Island. The next item is a compliance hearing. Item number 15, 2019-27BZ, 4533 18th Avenue, Brooklyn. Sorry.
Okay. We were holding up for, we were waiting for the LSC application. To date, it has not been submitted. We did receive fire department's letter of no objection with conditions. The applicant sent an email confirming that the applicant agrees to the fire department terms, and the applicant will appear at the public hearing today. So we will have to reopen the case, and we can discuss the matter then. But for the time being, we will continue to we will keep the compliance application open until the LSC application has been filed. Okay.
Okay. Decision items. Item number 16, 11211 BZ 2994 Cropsey Avenue, Brooklyn.
Okay. The revised zoning analysis sheet and signage analysis were provided. The applicant has removed the graffiti and is proposing to conduct weekly inspection of the site to address the graffiti painting on the site. I am very satisfied with the response, and I want to thank the applicant for quickly addressing the matter. So I make a motion to approve the extension, and I would want the note, a note be added into the resolution regarding weekly inspection to be conducted by the operator of the site so that the graffiti is not overlooked. With that, motion to approve.
Vice Chair Chanda. Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 17, 19705 BZ 813 815 Broadway.
All right. Make a motion to approve.
Vice Chair Chanda. Can you hear me, Vice Chair Chanda?
Aye. Aye.
Commissioner Otley Brown?
Can
Aye.
you hear me?
Yeah. It seemed to be like a delay. I don't know if it's me or you. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Aye.
Application has been granted. Item number 18, 106927 BZ 6702 6724 New Utrecht Avenue, Brooklyn.
All right. Just scrolling through my notes. The applicant has taken the necessary steps to restore the curb cut and sidewalks and has responded to board's comments. I want to thank the applicant for its prompt response. At the last hearing, the board had recommended a 20-year term in return for addressing all the comments and for doing the site improvements now. So thereby, I make a motion to approve for a 20-year term, and the same conditions as prior board approval still holds.
Okay, so on the motion to approve, Vice Chair Chanda?
Aye. Oh, sorry. Aye. I'm sorry.
It's Monday. Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Abstain.
Abstain. Okay. Application has been granted. Item sorry, give me 1 second. Item number 19, 2017-304 BZ 156 160 17th Street, Brooklyn.
A revised timeline and statement of fact and findings were provided. And the applicant states the expected completion date to be May of 2024. So with that, I make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 20, 2019, 58BZ, 13335 79th Street, Queens.
Okay. No submissions were required. Make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown. I'm sorry, General Counsel has his hand up before I finish the
Hello,
roll.
thank you. I'd just like the board to opine on the term, whether they'd like it to be an extension of 3 years from the date of today's grant.
Hold on. Yeah, yes. Thank you.
Commissioners?
Is that okay with everybody?
Yes.
Okay, they're
Yes.
nodding their heads in agreement. Okay. Okay, so can, let me continue. Let me redo the call then. On the motion to approve, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 21, 2021-2A through 2021-7A. This is 9921 Hollis Avenue, Queens.
All right, so we had closed the application in July and we're waiting for a DOT sign off. Now DOT sent, in response to DOT's comment letter from October 6th, the site plan was revised and specifically the applicant responded to DOT's comments 2 to 4, which pertained to aligning the curb cuts, driveways, and the sidewalk to be relocated to have a compliant sidewalks and tree pits. However, in its December 1st email correspondence, DOT asked for additional information with regards to showing where the planting would be in the front yard and where the parking would be. I just want to make this very clear to everyone who is listening in and for the commissioners is that the email the DOT sent, the comments that were posed there, those are not, those are all being regulated by the underlying zoning regulation. For example, the planting requirement on the front yard, the location of parking, all of these have to be pursuant to the zoning resolution section 23-451 and zoning resolution section 23-444 respectively. So board is not waiving any of the underlying zoning regulations. It is going to be built pursuant to the underlying regulations. So I do not believe the plans have to be revised and whenever GCLs are granted, our resolutions clearly state that we are not waiving any of the underlying zoning regulations. So what I would want to do is just put this for a second call tomorrow and give DOT enough time to sign off on comments related to 2 to 4 from their October 6th letter. And should that not happen, we can always fall back on conditions to granting the GCL. But I don't want to hold this up anymore. I want to make sure DOT did not say no or had raised any concerns or comments to the comments related to 2 to 4. So I would like the project manager and the applicant to work with DOT in making sure the comments related to 2 and 4 were addressed. Okay, is any Any discussions on this from the commissioners or general counsel?
Okay.
All right, thank you.
Okay, item number, sorry, let me just do this. Item number 22, 2022 4BZY, 529 President Street, Brooklyn.
Okay. Just give me a second. The application provided a response to board's comments, including the financial chart and the revised statement of facts. Are there any comments or questions? Okay, so I make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Oops, sorry. Item number, excuse me, item number 23, 2022 7BZY, 3875 11th Street, Queens.
All right. The applicant has provided an updated expenditure and has eliminated the finance expenses, specifically eliminated any costs that may have been included post December 2021. And the statement of facts has also been revised based on that. However, I think there might be still some discrepancy, but as I look at it, those discrepancies should in no way that it still continues to meet the substantial expenditure findings and meets the Putnam test. So I want to hear from the other commissioners, specifically Commissioner Otley Brown.
Yes, the discrepancy amounted to one check for $120 that was written on December 30th, 2021, and it does not disturb the findings at all. It's just a question of getting the number accurate for the resolution.
Okay, so what I would suggest, then the applicant just fix that so that the resolution indicates the correct number. But with that, sorry, it's, I think I made wrong. Oh, sorry. I may have mentioned Putnam incorrectly because the precedent one was Putnam related, I think. No, that one was also 11332 and this is also 11332. So yes, the substantial, my bad. We get so many of these, I get confused between the statutory and so my bad. So the applicant would still meet the findings of zoning resolution section 11-332 with regards to substantial construction and the expenditure part of it. So with that, I would still ask the applicant to just make those minor corrections as you heard from Commissioner Otley Brown and present that so that that can be reflected in the resolution. So with that, make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 24, 2020 44BZ, 2228 Garrettson Avenue, Brooklyn.
Right. No submission was required. I make a motion to approve with the following conditions. All light sources that are located on the lot line adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on the surrounding residences. Should the residential neighbors raise any concerns regarding light spillage onto the residential properties, the applicant should address it immediately. Signage along the side lot and property lot, lot line for car wash, regarding lowering the signage should be provided along this, provided and maintained along the side lot and property lines of the car wash regarding lowering the volume and that no loud music be played. And there shall be no use of rear lot abutting residential rear lot lines for repair or storage of vehicles or equipment. So with that, make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 25. 2021-61, I'm sorry.
Sorry.
Okay, should I go on?
Yeah, please.
Item number 25, 2021-61BZ, 4080 Ocean Avenue, Brooklyn.
No submission was required. So I make a motion to approve with usual conditions, that being that the removal of exterior walls and or joists in excess of those indicated on the BSA approved plan shall void the special permit.
Okay, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 26, 2022-8BZ, 18301 Horace Harding Expressway, Queens.
Revised plans were submitted in response to board's comments, specifically regarding the site improvements. I want to make a motion to approve with conditions that the site shall be secured and maintained free of debris and graffiti, and landscape shall be maintained per approved plan. The resolution shall refer to the sheets A&T 112.00 and 113.00 for compliance with site improvements. The resolution shall also include that the site maintenance and inspection that has been stated by Crown Castle. So with that, make a motion to approve.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Whoops, what did I do? Okay. Continued hearing items. Item number 20, special order calendars, continued hearing items. Item number 27, 7211BZ, 10106 Astoria Boulevard, Queens.
Okay. The application was last heard in February. At the last hearing, the applicant was asked to work with the abutting property owner in removing the graffiti from the wall of the abutting building. And the applicant has done that. Sidewalks and curb cuts have been repaired. Landscaping has been installed. Though based on the photos provided, it looks a little sparse, especially along the eastern, western and southern lot line. I would suggest that we close the application, and when the planting season comes next year, the applicant shall address the landscaping to be consistent with the plans, the revised plans that were submitted. Commissioner Otley Brown.
I agree with you that we should wait until planting season in order to insist upon the plantings being done as per plan. And I have no comments other than that.
But would you be okay to close it and make that a condition?
Absolutely.
Okay. Thank you. Commissioner Sheta.
Thank you, Vice Chair. I see that they submitted pictures.
You're a little
to the-
muffled.
Commissioner Sheta, your volume is,
Sorry about that. Is it better now?
No,
it's coming a little muffled.
yes.
Is the
No,
speaker?
now
are
you're
you-
muted.
Yeah, I'm trying to mute and unmute. Is it better anyway? Is it better?
Okay, it's better than before. Can you speak a little bit louder?
Yes, sure.
I will. Thank you.
No,
Okay,
there's good.
this is good.
Perfect.
This is
Yeah,
good.
I did look at the submission and I saw that they submitted photos for the graffiti removal and for the sidewalk and the curb cut work that they have done. And I'm okay with closing. The only thing that I would like ask them to update us, maybe send an email to the project manager or so about the community board. They said they will provide the recommendations when they are available. So if they have an update on that, I would urge them to update us on it. Other than that, I have no further comments. Thank you.
I think the applicant sent a letter, right, about the community board thing.
Yeah.
Uh,
They said they attended the land use community board, the land use committee within the community board, I believe. But regarding the recommendations themselves, they said they will provide as soon as they are available. And I'm, like I said, I'm okay with closing. We don't need to wait for the community since we don't have like any opposition. I'm fine with closing, but if they have an update, I would urge them to send it to us.
Okay,
I'm talking about the
thanks.
applicant.
Yeah, thank you. Okay. Commissioner Shibata.
Thank you, Vice Chair. I'm also okay to close this application. I have no further comments.
Okay. Thank you. Commissioner Yoon.
Thank you. I am also okay to close the application with conditions and have no further comments.
Okay. All right. So I would suggest the project manager reach out to the applicant and also ask them to follow up with community board, and if possible, we can also follow up with the community board. Okay. Bless you, Commissioner Sheta. Okay. Next case.
Okay, item number 28, 51957 BZ, 2071 Victory Boulevard, Staten Island.
Right. The application was last heard in March. A revised plan has been submitted in response to the board's comments, including providing a chain link fence around the trash enclosure, providing a landscaped buffer zone along the northern lot line abutting the residential use. And the applicant also removed a light source that was adjacent to the residential building, and also reduced the height of and the placement, reduced the height of the light pole that is located at the corner of the site next to the residential lot, and also added shields to minimize light spillage onto the residential portion. Photographs were also submitted, so I don't have any comments. I'm satisfied with the application. Commissioner Otley Brown.
I have no more questions. I'm fine with the application.
Okay, thank you. Commissioner Sheta.
Thank you, Vice Chair. I see that they did extensive work on the lighting. Hopefully it's gonna be okay, no complaints in the future. And I'm satisfied with the application as is right now. Thank you.
Great, thank you. Commissioner Shibata.
Thank you, Vice Chair. I'm satisfied with the application. No further comments from me.
Okay, thank you. Commissioner Yoon.
Thank you. I have no further comments.
The applicant just finished the bed of the planting. this is not the planting season, so I would hope, and that's a direction that the board will give. I think I would recommend closing, but one of the conditions of the approval when we do grant it would be that the applicant take advantage of the spring planting season of 2023 and do the necessary planting. So that would. Okay, thank you.
Okay, next item is item number 29, 174 96 BZ, 1108 Allerton Avenue, the Bronx.
Okay. This application was heard in September, and the applicant has submitted revised information, including a revised plan, statement of facts, proof of continuous use from 2019 to 2022. Also provided a board history, and a compliance chart also has been provided. The board had asked the applicant to delineate the 750 square foot of production area. The plan shows the retail area and the production area, and also the legalization of the storage area. I have no further comments on it. I'm satisfied with the application. Commissioner Otley Brown.
They've addressed my issues in terms of the proof of continuous use, which is since 2017, actually, not 2019. The variance, the previous grant expired July 2017. And they actually show street view photos starting with 2016 and moving on. They revisited the B finding and said that they would actually face a loss of $650,000 if they didn't have the spatial capacity to accommodate their largest customer. And they clarified the building square footage is now going to be 3,302 up from 2,812 square feet. And they clarified the hours, and I was fine with the hours of operation, and I have no more questions.
Okay, thank you. What is the, I don't have the information in front of me. What is the proposed floor area?
3,302 square feet, I believe.
Yeah,
And it was originally 2,812.
Okay, all right. Thank you. Commissioner Shetta.
Thank you, Vice Chair. I want to thank them for revising the plans. They fixed the call out that was confusing for the garage/storage. I thank them for that. This is the second hearing. Application is almost there. Very responsive. They listened, responded, so we got to the finish line. Thank you to the applicant. Thank you, Vice Chair.
Okay, thank you. When you say almost there, it's there, right? We don't have any additional comments or questions for them to respond to.
What I meant is it's gonna be, yep, I just realized. What I meant is we're gonna close today most likely, and it's not gonna be granted today. So there is
Okay.
the grant. And
Got it.
Yeah.
Thank you for that clarification. Okay.
I didn't mean I didn't mean that I have any like requests or comments on the case. I'm satisfied with the application as is. Thank you.
Great. Thank you. Thank you. Commissioner Shibata.
Thank you, Vice Chair. I found the application and the update satisfactory. I have no further comments.
Okay. Thank you. Commissioner Yoon.
Thank you. I have no further comments to add.
Okay. All right. Thank you.
Item number
Next
30,
case.
I'm sorry. Item number 30, 58482 BZ, 200 East 64th Street, Manhattan.
All right. So the initial hearing on this application was held in October of 2021. The application is for an amendment of the layout of a previously approved plaza. The applicant was basically was proposing to reduce the seating, increase the planting, relocate some of the mechanical spaces, and modify the hours of operation to reflect that of privately owned public space plaza spaces. At the last hearing, the board had raised several concerns regarding the layout, regarding accessibility, visibility, safety, and had asked to reconsider the design to address these issues that would make the privately owned public space, also known as PUBs, inviting and attractive for public to come and use. I would say it was worth the wait and 2 adjournments. The revised proposed design response to the comments that were raised. I specifically had raised, especially with regards to the accessibility, visibility from the street, and the safety through various designs and lighting elements. I want to thank the design team and the property owner for being responsive to the directions that were given by this board. The proposed plan makes extensive and substantive design changes, including providing an ADA accessible, providing ADA accessibility from the street level, and will also eliminate different levels of the plaza, especially along 3rd Avenue. While it reduces the total linear seating from 90 linear feet to 85, it allows for better connectivity and ADA accessibility from the street through the plaza. And the accessibility would be via an elevator, which would be visible from the street. The proposed plaza also increases the landscaping area through a combination of in-ground and vertical planting. No changes to the plaza size is proposed. It still will remain at 4,351 square feet. Also, I had asked the applicant to go through each of the PUB's regulations and its applicability to the subject plaza. The statement of fact has been revised accordingly. Both the existing and the proposed plaza, the proposed plan, the landscaping drawing, and the rendering should be, right now there are 2 separate packages. So the existing, the proposed plan, and the landscaping drawing and the rendering, that should be all be considered as one complete package. And we should approve the entire package. I have a procedural question for our general counsel and or our executive director, and that is, does this design need to go to city planning for review? Because the original application started with city planning and Board of Standards and Appeals coming to an understanding that since it does not meet the PUB's regulation, DSA variance would be required because it was elevated above the ground. So my question is, I think the original plan may have been reviewed by DCP. It's not clear to me. My question is, does this require a review?
We can look into that.
Yes, I was gonna say
Okay.
the same thing. We'd have to look into that.
Okay. Thank you. All right, those are my only comments. Commissioner Otley-Brown.
I have to say that I'm really impressed with the amount of energy and work that went into the redesign of this plaza. And I'm very pleased with the way it looks. The landscaping and the screening looks beautiful. And this is definitely going to be an asset to the community. The applicant team was very responsive. And as a result, I have no comments or questions.
Thank you. I agree with you. Commissioner Shetta.
Thank you, Vice Chair. I have no further comments to add, but I have a note. I put it back then when we hear this about the fines. I'm not sure if they paid the fines. I believe we asked them to pay before the decision. So if you want them update us on that.
Okay. Okay. All right. Thank you. Commissioner Shibata.
Thank you, Vice Chair. I found the submission very responsive. I was pleased with the plans that they submitted, and I look forward to this project becoming a reality. I have no further comments.
Thank you. Commissioner Yoon.
Thank you. I have nothing further to add.
Okay. Did you get a chance to review the design, Commissioner Yoon?
I did, and I did actually get a chance to go to the site. So I think I haven't been here for the past hearings, but it does seem like this is going to be a great improvement considering the current state of the plaza. It's not furnished and there's no plantings. and it's quite divided and unwelcoming. So I think I echo everyone's comments about how this is going to be an asset for the community and generally an improvement for this corner.
Thank you. I would like the applicant at the public hearing let me know what is the time frame to do this work. Would it be done in phases or would it be done in all one go? And if there is any capital budget that has been set aside by the building, by the management to do this work. Thank you. Next case, please.
Item number 31, 303-12. I'm sorry, Jill, you had your hand up? Jill, before I go to the
Hi.
next case.
I did have a question for the board on the POPs case.
Okay.
That's okay. The amendment is for the layout of the POPs. And it sounds like the board is happy with that. There's also an amendment for the hours of operation. It was a board condition. The hours from 6 a.m. to midnight. And in the statement, they did ask for an amendment to the hours.
You're right. Thank you for bringing that to my attention. I don't think at the last hearing we had much of an issue with it, but it would be worthwhile just to kind of ask all the commissioners present if you have any concerns with amending the hours of operation. Just so you know, the hours of operations for the current regulations of privately owned public space is 6 a.m. to is basically 7 a.m. to 10 p.m. April 14th to October 31st, and 7 a.m. to 8 p.m. November 1st to April 14th. The current hours of operation is 6 a.m. to 12 a.m. And you have to realize this was there partly because, if I recall, at that time, POPs did not have any specific hours of operations. Over the years, POPs regulations have been modified, and the proposed hours of operation will reflect what the current POPs regulations requires. And since we have asked the applicant to make a lot of the changes, which is more consistent with the current POPs regulations in terms of design, lighting, ADA accessibility, planting, I think in all fairness, we should also be accepting of the proposed change in the hours of operation to be consistent with POPs. So commissioners, Commissioner Otley-Brown, do you have any issue with the change in the hours of operations?
I have no issue with the change in hours of operation.
Okay. Commissioner Shetta?
Same here. Thank you.
Okay. Commissioner Shabeta?
I have no issue with the change in hours.
Okay. And thank you. And Commissioner Yoon?
I also have no issue. Thank you.
Okay, thank you. I would only say that if it is going to be closed during the site should be securely closed. There should be a way to monitor or chain or some gate or something should be placed to ensure that whatever the POPs regulation states, to ensure that safety is retained during off hours. So if the applicant can speak to that during the hearing, that would be helpful. Thank you. Thank you, Ms. Prenga. Okay, next case, please.
Okay. Sorry. Item number 31, 303-12BZ, 1106, 1108 Utica Avenue, Brooklyn.
Just give me a second. All right. All right. The initial hearing was held on October 3rd. The primary concern of the board was with regards to the existing condition of the fence and the financial commitment to develop the project. The applicant has repaired and relocated the fence. Photos have been provided. The applicant is also in the process of repairing the sidewalk and has filed for permit, and the invoice for the repair work has been submitted. A revised statement of fact has also been provided with regards to the proposed timeline. The applicant is basically proposing that by June of 2023, it would be able to secure funding and then be able to proceed to complete the DOB filing and complete the work by 2026. And a letter from the ownership's commitment, a letter has been provided from the ownership with regards to its commitment to develop the project. I wish the applicant a lot of good wishes in such times that we are in, but I do believe the applicant is working in good faith and is making every effort to make this project viable. Especially, I appreciate the applicant being responsive with regards to the sidewalk condition and proactively taking measures to repair it. Commissioner Otley Brown.
I agree with you on everything that you said. The applicant seems to have been very responsive to our requests, and I have no more comments.
Okay. Thank you. Commissioner Shetta.
Thank you, Vice Chair. I'm satisfied with the application and I have no further comments to add. Thank you.
Great. Thank you. Commissioner Shabeta.
Thank you. I am also satisfied, and I can tell that they're operating in good faith. The fact that they took their own initiative to repair that sidewalk when they saw for themselves that there were issues that wasn't something that we had to bring to their attention. They did that on their own volition. I'm satisfied with the application, and I have no further comments.
Great. Thank you. Commissioner Yoon.
Thank you. I also wish the best for the applicant and thank them for their responsiveness, and I have no further comments.
Thank you. Great. Can we take like a 15-minute break before we go on to new cases?
15 minutes, sure.
It's going to be a little lengthy, so it would be a good time to just take a 15-minute break. Okay.
So we'll
Thank
come
you.
back in 15 minutes.
It's 10:50, so that would make it 12:05.
11:05.
Oh, sorry. I'm sorry. 11:05. It's Monday morning, as you keep saying, Miss Matias.
Yeah. I get that caffeine kicking in. Okay, Steve, you want to put us on break screen? Thank you.
Good.
sorry, commissioners, please come back. Do we have a quorum? I
Steve,
don't
on
see.
the break screen, please. We have a quorum.
All right, we have all the commissioners. Okay, thank you.
Okay, we're back on the record. This is still the public review session. The new case item number 32, 16008BZ, 651, 67, 671 Fountain Avenue, Brooklyn.
This is an application for re-argument pursuant to board's rules and practices and procedures 1-12.4 that was dismissed by the board on April 11, 2022 for lack of jurisdiction for an extension of term of a variance and an amendment to the variance and for waivers of board's rules of practices and procedures under section 1-07.3 D2 and 1-07.3 B3 II. The prior variance had legalized the use of the subject site on the subject site for a commercial storage of motor vehicles with repair and accessory fuel storage in an R4 zoning district. In February of 2021, the applicant had filed an extension of term and an amendment for a change of use. The term had expired on July 13, 2013, and the time to obtain CO had expired on January 13, 2012. In April 2022, board dismissed the case for lack of jurisdiction, and the applicant has filed for an re-argument pursuant to the board's rules. BSA Rules of Practices and Procedures, section 1-12.4 states that the board will not grant a request to re-argue a case which was denied, dismissed, or approved unless the applicant shows that the board misapprehended the relevant facts or misapplied any controlling principles of law, including the zoning resolution. In all cases, the request for re-argument must be made on the SOC form stating the reasons for the request and may be accompanied by necessary supporting documents and or plans. As the board may recall that while the board noted in its resolution the unusual nature of the July 13, 2010 resolution, that it reserved establishment of the required zoning resolution section 7221C finding for a later date, dependent on the satisfaction of the implementation expiration only 3 years later, which would amount to a determination by the board that the implementation schedule had been satisfied, unquote. The majority of the board found that the requirement of the meeting of zoning resolution section 72-21 finding C was a condition for the grant and not to the grant, and that the implementation schedule constituted the board's findings under zoning resolution section 72-21C and was not a condition pursuant to zoning resolution section 72-22. I just want to read what zoning resolution section 72-22 is, which is regarding conditions or restrictions. And it states that the Board of Standards and Appeals may prescribe such conditions or restrictions applying to the grant of a variance as it may deem necessary in the specific case, in order to minimize the adverse effects of such variance upon other property in the neighborhood. Such conditions or restrictions shall be incorporated in the building permit and certificate of occupancy. Failure to comply with such conditions or restrictions shall constitute a violation of this resolution and may constitute the basis for denial or revocation of a building permit or certificate of occupancy and for all other applicable remedies. The majority of the board also found that the implementation schedule was not complied with, and thus the variance had not been established. The board's decision was regarding the jurisdiction for granting the extension of the term and did not deliberate on the extension of the term. Per board's rule, just give me a second. Just give me a second. Sorry, per board's rules, the documents provided by the applicant failed to demonstrate that the board misapprehended the relevant facts or misapplied any controlling legal principles to the specific questions based on which majority of the boards delivered its decision, based on which the majority of the board delivered its decision. Also, this is, I also want to read a section for the zoning resolution section 72-21, which was the variance, which is related to the variance. And all the way at the end, after all the findings are cited, the resolution states that it shall be a further requirement that the decision or determination of the board shall set forth each required finding in each specific grant of a variance and in each denial thereof, which of the required findings have not been satisfied. In any such case, each finding shall be supported by substantial evidence or other data considered by the board in reaching its decision, including the personal knowledge of or inspection by the members of the board. Reports of other city agencies made as a result of inquiry by the board shall not be considered hearsay, but may be considered by the board as if the data the data therein contained was secured by personal inspection. So again, what I said, per board's rule, the document provided by the applicant failed to demonstrate that the board misapprehended the relevant facts or misapplied any controlling legal principles to the specific question based on which the majority of the board delivered its decision. Also, I do not believe this is a forum for the board to make a new decision. It is for the court to determine. The board may only reach a different decision on the underlying resolution if the applicant is successful on a motion to argue. The applicant has filed for litigation. Now, the underlying variance, with regards to the underlying variance, the majority of the board had determined that there was none. So, and based on that, it was denied. So those are my thoughts. I do not think the applicant warrants a re-argument. I want to hear from the other commissioners. Commissioner Otley Brown.
I agree with you that the applicant does not meet the findings for a re-argument. I think that our resolution was extremely thorough, extremely detailed in how the majority of the board came to its determination and its final vote. And so therefore, I don't think that there's any evidence in the resolution that supports that we either misunderstood or misapprehended the facts and the law.
Thank you. Commissioner Sheta.
Thank you, Vice Chair. I agree with both of you. I don't believe, and it is my opinion, that the applicant failed to clearly demonstrate that the board, when dismissing the request to extend for the lack of jurisdiction, did actually misapply or misapprehend any of the facts or any of the law principles, and therefore I do believe that there is no reason for the board to allow for a re-argument on this case. Thank you.
Thank you. Commissioner Shibata.
Thank you, Vice Chair. I think this is quite a complex legal question here. I don't think that the applicant fully flushed that out. That being said, I was in the dissent on the original vote, and I do want to reserve comments until I hear the applicant's application today.
Okay. Okay. Thank you. Commissioner Yoon.
Thank you. As you all know, I was not part of the April 2022 hearing, but going through all of the documents that have been provided, I agree with you, Vice Chair, and with Commissioners Otley, Brown, and Shetta that I don't think that the case for re-argument has been made. I have no further comments.
Okay. Thank you. Okay. Next case, please.
Sure. Item number 33, 2017-232A, 1632 Richmond Terrace, Staten Island.
And I'd just like to remind the public that we are still in a review session. We see that you have your hands raised. When the board finishes its review session and begins the public hearing, when your case is called, we will invite you to speak as part of the applicant team, or if you're part of a member of the public, we will inform you of your time to speak. Thank you.
Did you read out the next case, Ms. Matthias?
Yes, would you do it again? Item number 33, 2017-232A, 1632 Richmond Terrace, Staten Island. And yes, we are still in review session.
Okay. We have received proof of service of initial filing and public hearing. This is an extension of time. Proof of service of initial filing and proof of hearing is not required for extension of time. This is an application for an extension of time to obtain a CO, which expired on July 17, 2022 for the construction of an as-of-right use located along a built but unmapped street called Richmond Terrace. As you may recall, back in 2018, the board had granted a GCL 36 for the construction of an as-of-right use group 16 storage facility located on Richmond Terrace. It had conditions from DEP and fire department. And one of the condition was that the CO be obtained by July 17, 2022. The applicant is seeking for that extension of time. The building is complete, as you can see from the photograph. I would like the applicant to provide the DOB approved site plan only, because everything, I don't care about the interior of the thing. We approve the site plan, especially with regards to fire department access condition and with regards to DEP's SCP. So with that, I also want the applicant to clarify if the sanitary and storm pipes have been constructed as per the SCP ID number 5659 that was approved on 9/15/2017. And also the applicant needs to indicate that the built condition complies with the fire department conditions that were stated in its April 30th, 2018 letter of no objection, including like no standing anytime fire zone, and those were indicated in the BSA approved plan. So I did not see the DOB approved plan, or the photographs did not quite clarify if these conditions were met. So the applicant needs to provide those information. The applicant states there's been the delay has been due to construction delays, has been due to pandemic. Though all the work is complete and it's awaiting inspection to secure to obtain a CO. Those are my comments. Commissioner Otley Brown.
I have no additional comments.
Thank you. Commissioner Shetta.
Thank you, Vice Chair. I have some comments. I wanted them to update us on the status of the construction. Let us know if there is any modification, or confirm there is no modifications or modification to the drawings / construction. let us know if there is any violation. And I have noticed that they didn't submit a copy of the drawings. They just submitted the previously approved. If in my opinion, if in extension cases, the drawings previously approved are okay, I'm okay with them, with taking just these drawings, provided that the applicant confirm no changes to the drawings / construction. If this is the case and the board is okay with that, I'm fine with just the previously approved drawings. But the reason I'm raising this, because on other cases, I've seen applicants submitted both the previously approved and assigned and sealed. So it's up to the board to decide which way we want to go. Thank you.
All right. I just want to alert everybody, this is a GCL 36. So a GCL 36, as you know, the board does not waive any of the underlying regulations. All that the board is approving is related to its placement to an unbuilt mapped portion of the street. So in this case, the board did not grant any waivers of bulk. So it was all pursuant to the underlying regulation. So that's why I specifically asked. What we had approved was just the site plan. We did not approve anything interior because that was all, as of right, we didn't need to. We just need to look at this. That's why I suggested that they only submit the DOB approved site plan to ensure that that it is meeting all the requirements specifically related to fire department, because those affected the location of where fire department wanted the fire lane, the turning radius, any of the signage, especially with regards to in the BSA approved plan, which says there has to be a 25-foot wide curb cut to be used for fire department, roadway warning stating no standing anytime, and there has to be a proposed retaining, there has to be a retaining wall, there has to be a fire department connection. All of those were the conditions that were on the BSA approved plan. So I want to make sure that, okay, so that's what you want. I just want to be clear.
Yeah, I said for this case and even other cases when the board even stamp detailed drawings, this is my opinion. I believe if the applicant
go ahead, finish your sentence.
Yeah, I believe if the applicant submits the previously approved drawings and affirm on the record that there is no changes, I'm okay with taking the previously approved. And I thought you, Vice Chair, meant the previously approved site plan, not that because you said DOB approved site plan. But I'm fine with it in this case. And even in other cases where we stamp detailed drawings like the floor plans. What I'm saying is on cases where we stamp the detailed floor plans, I saw that applicants submit a new set of drawings, signed and sealed. I'm okay with that. And on this case, I'm okay with doing same or just taking the previously approved set and go with it. I just want to be like, I wanted the board be consistent. And if we want to differentiate between GCL, where we just stamp the site plan, and other project where we stamp detailed drawings, this is also fine for me.
Okay, so in this case, we only approved one set of plan, and that was a site plan.
Right.
And so all the applicant needs to do is either provide a certificate of letter of some sort that confirms that all of these conditions are met, and I would still think it would be good for them to submit a DOB approved plan of the site plan.
Okay.
With all the notes that were put in there, because these were conditions, and those conditions need to be met. Okay, thank you. Thank you for that clarification.
You are.
Commissioner Shibata.
Thank you, Vice Chair. So I am sympathetic to this applicant. I think that it's their extension is reasonable. and pending their response to your questions and production of documents, I have no further comments.
Thank you. Commissioner Yoon?
Thank you. The applicant did submit on, I think, November 28th, their violation history, which it looks like based on the submission, it was taken September 1st. But just to answer Commissioner Shetta's question, it looked like at that time they didn't have any open violations, and then looking on Biz now, they still have no open violations. Of course, the applicant can confirm that. I have no further comments to add.
Thank you, Commissioner.
Thank you, Commissioner Yoon, for the clarification. Okay, all right, should we go to the next case?
Yeah. Item number 34, 2017-306BZ, 1977 East 14th Street, Brooklyn.
Okay. So we have received proof of service of initial filing and public hearing. Community board voted to approve this application. This is an application for an amendment to a previously granted special permit pursuant to zoning resolution section 73-622 to enlarge an existing one-family home. Back in 2018, a special permit was granted for the enlargement of the existing home that was contrary to the rear yard and side yard. No waiver of floor area ratio was required. The applicant is proposing to amend the previously approved plan and is not proposing to change the rear yard depth and the side yard width. There is an increase in the total floor area. However, the increase in the proposed floor area is still within what is permitted under the underlying zoning district. So it doesn't require us to review that part of the element. The proposed modification will also reduce the building height from previously approved 37 foot 6 inches to 36 foot 9 inches, and the perimeter wall height from 25 foot 4 inches to 23 foot 10 inches. No change in the removal. There's no proposed change to the removal of the existing exterior walls and joists. Well, the only change in the joist is that instead of the change in the joist on the second and the third floor, it would be on the cellar, the roof of the cellar and the roof of the ceiling of the cellar and the ceiling of the first floor, as opposed to ceiling of the first floor, ceiling of the second floor. No change in lot coverage or an open space is being also proposed. So based on all of this, the change, I believe, is minimal and does not alter our findings. And one of the conditions of the 2018 special permit that a certificate shall be obtained by December 4, 2022. So we are already past that date. So the applicant must submit an extension of time application. I have a procedural question for our general counsel and or our executive director, which is, will it require a separate application or will it be an amendment to the current application for extension of amendment to the drawings? And so that's the question I have. You can let me go through all the commissioners and maybe you can answer that question after I'm done with all the commissioners. Commissioner Otley Brown.
I have no questions on this case.
Okay, thank you. Commissioner Shetta.
Thank you, Vice Chair. I am satisfied with the application. And if procedurally it is okay to convert this application to an extension and amendment, it would be good to do it in one shot. I'm okay with that.
Yeah.
Thank you.
I agree. And that's the question I have for our general counsel and our executive director to clarify.
Okay,
Sorry.
council's hand is up. Do you want to say now?
Yeah.
or-
Yes.
Thank you. Thank
Yes.
you. And just for the record, just
Yes.
want to confirm we're on 2017-306BZ,
Correct.
which, so this is a little interesting. So pursuant to an executive order that was issued by the mayor for the COVID state of emergency. 7370, which is now 7380, the lapse provision for special permits was told, as well as 7223 lapse provision for variances. They were both told pursuant to Executive Order 110 for 475 days. The underlying grant of this special permit, which is under 7380, was issued on December 4th, 2018. The tolling period pursuant to the executive order, which is March 12th, 2020 to June 29th, 2021, inclusive of those dates, so 475 days, intersects with their time to substantially construct and not lapse pursuant to their grant. Therefore, their time to substantially construct should, pursuant to tolling of the executive order, give them until about March 24th, 2024. I would suggest that the board does not need to require that the applicant seek that additional action here. To the extent that the board does issue a resolution approving anything here on this calendar, we can reflect everything that I have just stated with respect to the executive order and the board's position with respect to the time to substantially construct, and therefore obtain a certificate of occupancy, adding the 475 days to March 24th, 2024.
Thank you
Wonderful.
for that clarification. Yes, thank you. Thank you very much. Great. Thank you.
But I would just add that I would just add that if the applicant is not satisfied with that and that route, the applicant is welcome to seek those. If March 24th, 2024 is not going to get them what they need, and they would like to now file for this, that is always an option as well.
Okay. All right. Thank you. Thank you for that clarification. This is very helpful. Commissioner Shibata.
Thank you, Vice Chair, and thank you, General Counsel. I have no further comments on this case.
Okay. Thank you. Commissioner Yoon.
Thank you. I also have no further comments.
Great. Thank you. Next case, please.
Appeals calendar, continued hearing items, item number 35, 2018-188A and 2018-189A, 194-28 and 194-32 Dunton Avenue, Queens. And did the board receive the letter I sent over from the applicants last week? Thursday.
I don't. Hold on.
It was
This
dated
is
November
dated
30th.
30th. Yes. Yes.
Yeah. I didn't adjourn this because I wanted an update for the board. I thought it was more important to sort of see where they are
Yes.
and what you want to do.
Yes. Yes, the application was last heard in September. And at that hearing, fire department had asked the applicant to provide a clear path for fire department to access 87-37 Palermo Street site. The applicant in its latest letter states that the effort is being made to clear the site and is working towards resolving outstanding ECB violations and hopes to have the site cleared for access. There was a partial stop order in place, which was rescinded. And we had also asked the applicant to provide, it is our understanding that a portion of the site is going to be sold to another, and it's currently in that discussion. However, the change in ownership has not occurred to date, and the applicant has did not provide any update regarding that. And we were also waiting for DEP and DOT sign off, especially with regards to the GCL 35 portion of the site. And so we need that before we can close. So I would want the applicant.
Oh, I'm sorry.
Sorry, go ahead.
No, I did reach out to DOT. I haven't received anything yet. I reminded them again about the hearing. DEP I think they're still holding to their comments. There is a issue with the architect and the previous architect. So who has the authority to, I think the applicant should explain it about filing the BPP. So that may be something that the applicant's going to discuss. So.
Okay. Okay. So the applicant is aware and will be present at the hearing?
Yes.
Okay. Thank you. Commissioner Arthur Brown?
I have no questions.
Okay. Commissioner Shetta?
Thank you, Vice Chair. I have no comments on this case.
Okay. Thank you. Commissioner Shibata?
Didn't hear you.
Commissioner Shibata, could not hear you.
On this, I'm not sure why this isn't. Do you hear me now?
Yes, sir.
Yes.
Okay, so I have no further comments on this.
Okay.
Thank you. Commissioner Yoon?
Thank you. I have no further comments.
Okay.
Okay. New cases, item number 36, 2022-62A, 34 West 38th Street, Manhattan.
All right. We have received proof of service of initial filing and public hearing. Community board has waived its right to opine on this application. The action requested before us is that the applicant is seeking a common law vesting to renew the building permit that was lawfully issued before December 20, 2018. The effective date of the zoning text amendment with regards to hotel for the completion of a 20-story transient hotel that is underway in an M16 zoning district. The application, which was filed under the common law doctrine, is articulated in the Putnam Armonk v. Town of Southeast. In the case of common law vesting, 3 prongs of Putnam Armonk must be met. And those are the substantial construction did occur, substantial expenditure was made prior to the effective date, which is December 20, 2021, and that in the absence of the vesting relief, the owner will suffer serious loss. With regards to specific provisions related to the hotel use as part of the zoning text amendment, section 42-111, section E, which is regarding the vesting, states that in the event that construction has not been completed and a certificate of occupancy, including a temporary certificate of occupancy, has not been issued by December 20, 2021, the building permit shall automatically lapse and the right to continue construction shall terminate. An application to renew the building permit may be made to the Board of Standards and Appeal no more than 30 days after the lapse of such building permit pursuant to the applicable provisions of section 11-332. The hotel text amendment was adopted on December 20, 2018, and the amendment requires a special permit for new hotel in M1 zoning districts. This text amendment has a provision, as I read out, for the vesting, and based on that, the threshold factor per zoning resolution section 42-111E vesting is that the lawful issuance of building permit, and DOB letter dated 9/19/2022 confirms that the DOB did issue a permit lawfully, and the permit was issued on April 23, 2018, which gave the predecessor in interest the right to continue or start off construction. So the board then needs to find the 3 prongs of Putnam Armonk if they were met. And the first one, as I said, the first prong is that substantial construction has been completed prior to the sunset date of December 20, 2021. The applicant states that the foundation and earthwork permit, construction equipment permit, demolition permits, new building permits were issued prior to April 23, 2021, and a post-amendment approvals were approved in December 2018 prior to the completion date of December 2021. And an affidavit of construction timeline by the owner has been provided, and also for the construction expenditure. It states that a full demolition and 100% of the foundation was completed by the effective date So based on that, I believe the applicant meets the first prong of Putnam Armonk. With regards to the second prong, it states that that substantial expenditure has been made. An affidavit of financial information has been provided by the owner, and according to that, about 7.6 million has been spent both in hard and soft costs from February 2017 to November 30th, 2021. Although the owner's affidavit, invoices, and expense summary sheet has been provided, documenting that 5 million of invoice and canceled checks of the 7.6 million expenditure were made prior to the effective date. So owner estimates about 90 million of total expenditure. So taking in the lower number, 5 million, because that's where the checks and other things were being documented. So just erring on the conservative side, $5 million of expenditure constitutes about 9% of of the total estimated expenditure. There is no fixed formula to measure substantial construction and substantial expenditure when it comes to common law doctrine, which is broader than the statutory vesting under zoning resolution section 11-331. And the evidence provided meets the second prong of Putnam Armonk, even applying the conservative amount of 5 million. With regards to the third prong of Putnam Armonk, which is serious loss, the applicant states that a conforming manufacturing or commercial use would have a different footprint and would not be able to make use of the excavation foundation or footing. Furthermore, due to difference in live load in hotel and office use to accommodate the additional live load for a conforming office use, significant modification would be required to the foundation. The applicant did state something about a one-story manufacturing warehouse. I think, given that this is a site in Manhattan, in the heart of Central Business District, a warehouse facility in this area is very unlikely from a use point of view, a viable use, that is. Most likely an office use is possible, and I don't think that argument flies, and I don't even think it's necessary. I think the main element is that should there be any change in use required to be compliant with the underlying regulation, it would require the applicant to go back to the drawing board, revise the plans, and get all the necessary approvals, reapprovals on the plans, engineering, and plumbing, mechanical, and etc. So that would be that would result in serious loss and additional expenditure, and I am satisfied with that understanding that the applicant meets the third prong of Putnam Armonk. Commissioner Otley Brown.
So I agree with basically just about everything that you said regarding this case, but I just wanted to question one thing in the soft costs, which is in the inclusion of the loan closing, extension, and financial for a total of $906,000. What is that in reference to? Is that the site sale or is that the construction loan? Because if it's the site sale, I don't know if it should be included. If it's the construction loan, I would assume it could be included because it's towards the construction of the building. So if they could just detail that. And then as to the serious loss, I agree with you in that I wasn't convinced by their argument because number one, they focused in on a one-story warehouse having a full footprint. And they talk about how the rest of the floors of this proposal would have to be demolished. However, when they talk about the work completed, they've only completed the foundation and one story. So there would not be that extent of demolition that they talked about because it technically hasn't been built by the threshold date. And so to me, they should focus in on what would happen if they had to redesign, and that would result in a loss in architectural engineering fees and permits, as well as having to perhaps redesign the interior of the first floor and the cellar, which would result in demolition of partitions and installation of new partitions, and that could be costed out. And then they can also talk about the loss in income between the 20-story hotel and what they would need, what they would actually build as of right, which would probably be some sort of commercial office building. And that would make the findings right there. And so those are my only comments.
Thank you, Commissioner Otler-Brown, for that clarification. Very helpful.
Thank you, Commissioner.
Commissioner Sheta.
Thank you, Vice Chair. I agree with both of you that the findings are met. On the first finding that a permit was lawfully issued on or before April 23rd, 2018, I saw a letter from DOB confirming that. On the substantial expenditures they submitted, they made a very well-prepared submission on detailing the expenses they accrued. On the substantial construction, I do believe that finalizing the excavation, the SOE, and the foundation work can be considered based on other cases that we looked at, can be considered as substantial construction completed. The other findings is the serious financial loss. I do believe that, and I do agree with them, that if they want to consider an office building, let's say, that they will need to pay for a redesign, they will need to probably pay for modifications to the existing foundation that they already installed, whether this is an office use or it's a warehouse. I do believe if they want to switch to an office use, even that, like the cost for the changes in redesign and reinstallation of foundation elements would be much less for a warehouse, 1-story or 2-story warehouse. It wouldn't be like feasible at all to switch to that kind of a lightweight building when it compares to a hotel, a multi-story hotel. The only thing I didn't like on this application is that although they made a very good submission on the financials, I haven't seen like any pictorial evidence on the work completed by the cutoff date. The only thing I have the only reason I'm satisfied with this application, because I went to Google and I looked at the street view, and in the street view I went back to July 21st, and I can see the dowels for the foundation walls and for columns and probably shear walls, but the construction fence actually is there and it's holding the line of sight. So if they can provide us with some pictures, if they didn't, that would be very helpful. If they did, just guide me to where they are. Thank you.
Okay. Thank you. Thank you very much. Commissioner Shibata.
Thank you, Vice Chair. So based on the three-prong assessment that we are guided by in Putman, I believe that one, that substantial construction has been completed, in that there was excavation and foundation work is complete. I believe that there's substantial expenditure. I think they did a good job at providing us evidence of the $5 million in expenditures that they already had either incurred or paid. And with regard to the serious loss, for me, I believe this issue is settled, although I do want to, I do appreciate what has been asked of the applicant and await to see what they provide.
Thank you. Commissioner Yoon.
Thank you. I do see in the file, we have photographs that are dated from August, and they detail from December 20th, 2018, and then also the progress at December 20th, 2021. which I think is the date in question. There isn't much progress in between those dates, but it does look like the substantive construction occurred anyway by 2018 for the cellar and foundation work. I went to visit the site and it does look like it's still in the same place where it's not above the ground yet. But it does seem like the finding has been met. And I think for the serious loss, I do understand they make an argument that the foundation as designed would need to be redesigned in the event of a use that's a commercial or warehouse, because the spans would need to be larger. And I do believe that that would be true in order to make a viable commercial or warehouse use. And so there would have to be some significant modification because hotels require or can work with a different type of closer column spacing or bearing spacing than those other uses. So I think that the serious loss would be to go to a conforming use would require a significant redesign of the foundation and the spacing of the structure. I am satisfied with the application, but do look forward to hearing the applicant's response to the other commissioners' comments. Thank you.
Commissioner Sheta, you had your hand up?
Yep, thank you, Tony. Actually, I wanted to say my bad. Actually, I have it in my comments. I have it that I looked at the photos and I saw the construction photos there, but I thought they didn't submit any pictures. So I want to withdraw my comment regarding submitting pictures. I'm looking at them right now, actually. Thank you, Commissioner Yoon.
Okay, thank you. This is called teamwork.
It
All right,
is.
great.
Yep, thank you.
Okay, so any more comments?
Nope.
No, okay, so this concludes the public review session. What do you want to go further? You want to go into a public hearing? It's 11:49.
11:49.
Commissioners are shaking their head, yes.
So do you want to continue? Okay, all right, let's continue with the public hearing.
Okay. Steve, put the screen up, please. Thank you. My code sheet. Okay, we are now on the board's public hearing for December 5th, 2022. I will call the case, and once the commissioners have discussed the case, that then we'll open up to the public. That's when you'll have your opportunity to present and respond. The first item up is special order calendar, continued hearing items, item number 27, 7211BZ, 10106 Astoria Boulevard, Queens. Oh, wait. You didn't want to, the decision is tomorrow, right? For Hollis, you want to do that tomorrow, correct?
Yeah.
Okay, so we'll leave that.
Because second call, we're doing second call, just it's for us to reach out to DOT and make sure they're okay with the changes that the applicant has revised, especially with regards to the curb cut alignment, sidewalk, and that the applicant has provided the required sidewalk width that is compliant with all the regulatory controls.
Okay.
Those are the specific elements I want DOT to weigh in on. The others are totally within the purview of DOB, since we are not waiving any of the underlying regulations.
Item number 20. Oh, sorry. Am I missing something, Jill? Yeah, Jella, thank you. Sorry. Thank you, Jella. That's what happens when you put something in the middle of decisions. Thank you, Jella. The first item is item number 15. That's the compliance hearing. 2019-27 BZ 4533 18th Avenue, Brooklyn. I apologize.
Hi, how are you?
Hi, how are you?
Thank you, Jella.
Sorry. It's actually Jella's case, so she would know.
Yeah.
Sworn testimony. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
State your name for the record and proceed.
Good morning, Jay Goldstein on behalf of the congregation, the applicants. I know that we were supposed to submit the LSC after the last compliance hearing. We received from the fire department on Friday afternoon the revised LNO, which is what we were waiting for. and we thank them very much for their help and consideration on this. It's going to save the congregation a tremendous amount of money. Now that we have that in hand, we can finalize the LSC and submit it to the board for review. So we're ready to proceed. We were waiting on that last piece. And again, we thank the board and thank the fire department.
So any questions or comments? Do you have a timeline as to when you will be able to file?
I have them. I sent this morning just to update the plans because we have to revise a lot of the notes and a lot of the sheets. I'm hoping to file within the next week or two.
Okay.
And then I don't know what the LSC meeting schedule is.
We will let you know.
Perfect.
Now that you brought it to our attention, we'll keep an eye out for it.
Okay, I appreciate it.
So I think, as you heard me state at the hearing, we will still wait for the LSC application to be filed, and then based on that, we will withdraw the compliant one. So we won't do it today. We'll do it
That's
after
fine.
the LSC.
No, I understand. I appreciate it.
Vice Chair, Commissioner Shetta's hand is up.
Thank you, Tony.
let me sorry, hold on. Let me just go through all the commissioners.
Yeah.
Oh, I'm sorry, Commissioner. I apologize, Commissioners.
Yeah, Commissioner Brown, do you have any comments?
No comments.
Okay, thank you. Commissioner Shetta?
Thank you, Vice Chair. I don't have a specific comment. It's just a confirmation request from the applicant. As far as you know, that on during the hearing of this application, from the perspective of you, if you see something, say something. On the structural aspect, we raised concerns regarding the structural health of
Right.
the building. My understanding is that the applicant has worked with the FEU, the Forensic Engineering Unit at the DOB. I have seen some correspondences actually submitted to us. I'm okay with the submissions made. I have no further comments, but because what I have seen is like a protocol to perform some testing, I need a confirmation from the applicant that the structural issues will be handled in a proper way and in compliance with the requirements from the DOB.
So my understanding is that actually happened. That's how we got through with Mr. King from who was part of the initial hearings from DOB. We went through the protocol, we did the testing, he was satisfied, and we're able to get permits now. So with the LSC, we'll be able to pull the permits, and I think everything with regard to concerns for structure and stability, I think that was everyone was happy.
So you're saying the testing is already done, because what I have seen is like a protocol or / procedure
Right.
for how the testing is going to be done. But you're saying now that the testing is already done, right?
I believe the testing was done, but I can't affirm to that. I can't swear to it. So all I'll say is that I know they were working with Mr. King. I was not involved because Mr. King wanted to keep it with the professionals, not with the attorneys. So
Understood.
Mr. King reviewed all their protocols. He was involved on the day-to-day and gave them permission to pull permits for the change of use and the minor modifications to the building as the plans indicated.
Okay. If you can confirm it with your professionals, that would be helpful.
Okay.
This is
no
not
problem.
for us. We have nothing to do with the structural issues, but this is for the congregants, you know.
Right. It'll definitely be done. If I know the protocol was established, I know they were happy with it and they allowed us to go to DOB. I believe the testing was done and this is on their radar. So during the course of the project, it'll absolutely be done. Safety will be taken into account because it's on the radar of everyone involved.
Understood and confirmed. Thank you.
Forensics and special enforcement were all involved in the initial application. So it's on everyone's radar.
Yes, I totally understand. Thank you, Jay.
Appreciate it. Thank you.
Commissioner Shibata, do you have any questions or comments?
No, I do not.
Thank you. Commissioner Yoon?
I have no comments to add. Thank you.
All right. Do we need to go to public for public hearing on compliance?
I don't know, Chase?
No, we do not.
No, right? We're not required to. Okay.
Okay. So can we close? Do we need to close it to withdraw? Or we can close and withdraw at the same time?
That can be done at the same time, but
Okay.
we're not
All right.
withdrawing, but we're not prepared
Right.
to withdraw this compliance hearing yet today.
Right. So we won't withdraw the compliance hearing now until the
LSC is taken care
LSC. Yeah, I was just going to upgrade you to LNO, but
of. I make less money that way. I don't know.
At least you're
we
honest.
All right. Thank you, Mr. Goldstein, and we will keep an eye out for the LSC application.
Thank you very much, everybody. Have a good day. Bye.
Thank you.
Okay, now the special order calendar. Continue hearing items, item number 27, 7211 BZ, 10106 Astoria Boulevard, Queens.
All right, I'm just scrolling through the sheets, going past the decision. Next time, I will make sure the compliance comes after the decision.
Yeah, sorry about that. Yeah. Should've
yeah.
moved it.
Yeah, I live and learn. I will also make sure. So who is the applicant? I think it would be Mr. Rothkrug.
Rothkrug.
Yeah.
Preston Rothkrug? Want to let him in?
That's my son. I don't know how that came up.
It's one of the twins, sorry.
That's very funny.
You have
right,
your video on, Hiram?
I'm trying to. How do I put my video on?
Accept as panelist, you could accept as panelist. But
Oh, here it is. Start my
This-
video. Yeah,
Yeah, it's on
yes.
the bottom.
Here I
There you
am.
go.
Hey, everyone. Hey,
Hi.
Tony. Hey, everyone.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do. Thank you.
Okay. You heard the board's comments at review session?
I did. Good morning, everyone. Good afternoon. Hiram Rothkrug for Vassalotti Associates, the applicants for the Luke Oil Station on Astoria Boulevard. We've put in a lot of work into the station, as the board is aware. We fixed the sidewalks, curb cuts, graffiti removal. We've put in some landscaping. We still have a little more additional landscaping to put in, which they did not want to do until all the concrete work had been finished on the sidewalks and curb cuts. Now that that's been done, I'll try to get a schedule as to when the additional landscaping will be put in. We had a meeting, an in-person full public hearing with Community Board 3. We believe, I didn't wait around for their vote, although I do believe it was a unanimous vote approving the extension of term. I've been in contact with the community board even up to this morning, asking them to communicate their results to the BSA from Miss Giovanna Reed, the district manager. They were going to call me back. I didn't receive a call back in the last hour that I spoke to them after our hearing. So I think the community board satisfied. Hopefully the BSA is satisfied, and we've come a long way on the application, and it's a nice looking station right now.
Yes, yes, I do want to thank you and your client for fixing all the issues that were raised, and recognize that a lot of work was done to allow for new planting, and when the planting season is there in spring, you will take care of it. And that is something, I'm going to recommend that we close it, and that is one of the conditions I'm going to put in. But if you can also, you said you will get a timeline of the planting. If you can provide that in writing, that would be helpful.
Absolutely.
Okay.
Any questions or comments from the commissioners? Nobody seems to have any questions. They're shaking their head left to right or right to left. Let's go to the public.
Okay, the case we are currently discussing is 7211 BZ 10106 Astoria Boulevard, Queens. It's an extension at the time of an auto service station. Should you wish to discuss, you may call in 646-558-8656 or a toll-free number if you're outside the city, 888-475-4499. And you will enter the webinar ID number 875-1461-9752 and press the pound sign. At the next prompt, you will press the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute if you are on the phone. If you're in the Zoom room already and wish to speak on this application, please raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're in, you'll have 3 minutes to speak. Time starts now.
3 minutes? I thought we reduced it to 2 minutes.
No, 1 minute to wait for someone to call in and 3 minutes to speak.
Thank you. Thank you. Yes, you're right.
Or you can change it if you want. It's up, depends on how.
No,
many
no,
people-
no, 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 no. I misheard.
Okay.
Thank you.
Meanwhile, I don't know, any time frame for the applicant?
I think the only thing we need is a letter from you, Mr. Rothbrook, providing the proposed
Shoot,
timeline
sorry.
for the landscaping.
Correct. I'll try out, if I could have it for the board later this afternoon or tomorrow morning, I will do that. Absolutely.
Yeah, well, we won't vote on it tomorrow.
No, I understand. I just want to tie up loose ends and get it into you as quickly as possible.
Okay, 1 minute is
great.
passed.
And while you have it, you can again just reach out to the community board and get their approval also submitted. Most likely we will schedule this for I'm going to recommend that we close and we will schedule this for a vote sometime in January or maybe depending on the schedule or in February.
Okay, the motion to close, Vice Chair,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Okay.
Okay.
Next
Thank you,
item,
Mr. Rothkirk.
stick around, Mr. Rothkirk.
I'm here.
Item number 28, 519, 557 BZ, 2071 Victory Boulevard, Staten Island. Raise your hand again. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do. Thank you.
State your name for the record officially.
Once again, Hiram Rothkook for Basilati Associates, the applicant for the gas station at 2071 Victory Boulevard. We listened to the board's comments this morning. I just want to go back to our original hearing with the board to just reinforce, to let the board know that the community board voted unanimously in favor of the station. They were very positive and had a lot of nice things to say at their community board meeting. During the course of the board hearings, the board made several recommendations on making this station perhaps one of the nicest stations in the city of New York, certainly the borough of Staten Island. And I think we've achieved that. We've, as the chair mentioned, we've put in screening around the trash dumpster. We've repaired all fences. We've put in new landscaping. We've put in new beds for landscaping. We did a new light study. We've put shielding around lights, removed lights, and we think we've met all of the board's requirements for this station at this time. I would like to tell the board that I was advised that trees were just installed on the site later last week, and I will have new photos into the board shortly showing that the landscaping has been planted.
That's good to hear.
Yeah, absolutely.
Yeah, luckily we have had a reasonably warm winter, so I'm glad your client took advantage of that and did the planting. So do provide the photos. That was one of my comments. Any questions or comments from the commissioners? Okay, all right. Let's then go to the public.
The commissioners have indicated they have no further comments. Want to put the screen up, Steve, please? Thank you. The case we are currently discussing is 51957 BZ 2071 Victory Boulevard, Stanton Island. This is an extension of term and an extension of time to obtain a C of O for an automotive service station. Should you wish to discuss, please dial 646-558-8656 or our toll-free number 888-475-4499 should you be outside the city. Enter the webinar ID number 875-1461-9752 and you will press the pound sign. At the next prompt, you will press the pound sign, only the pound sign. Once you're in, you can press *9 to raise your hand, *6 to unmute if you are on the telephone. And if you are in the Zoom room already and wish to just speak on this application, please raise your Zoom hand, which is the tiny hand, the hand that is on the bottom of your screen. Once you are permitted in, you will have 3 minutes to speak.
Okay. I think the planting was the only thing, and you said the trees have been planted and you'll provide photos. Again, recommend closing, and we will try to schedule it at around the same time as the prior application, end of January or February. For
That's
a vote.
terrific. That's terrific.
So if
Thank
you
you.
Great,
Okay.
thank you.
Almost done. Okay, 1 minute is up. Okay, so do you want to make that motion, Vice Chair?
Yes, a motion to close.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Vinroy, you have your hand up? No, never mind. No,
sorry.
No, never mind. It was my thing. Sorry. It was my screen thing. Okay, sorry. Next item number 29, 17496 BZ 1108 Allerton Avenue, the Bronx. It should be
I think Alexia Landsman.
Mhm. Unmute. Okay, great.
Can you hear me?
Yeah, great. You want to raise your right hand? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay.
My name.
Go ahead.
Oh, I was just going to say hello, everybody. My name is Alexia Landisman. I'm presenting on behalf of the applicant from Sheldon LaBelle PC. We attended the executive session and it seemed like there were no additional comments for this application. And so I think that's hopefully we'll be able to close today.
Yes, thank you. And thank you for providing all the information, making the corrections. I know that some of the corrections were asked at the last moment, so thank you for taking care of those. Any questions or comments from the commissioners? Okay, they're
Commissioners
saying
indicating
no.
no. Okay. Sorry, I didn't mean to speak over you, Vice Chair.
No, that's quite okay. Let's go to the public, please.
So the case we are currently discussing is 17496 BZ 1108 Allerton Avenue, the Bronx. This is an extension of term for a existing food manufacturing establishment. Should you wish to discuss, dial 646-558-8656 or our toll-free number 888-475-4499 should you be outside the city. You will enter the webinar ID number 875-1461-9752 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're in, you will press *9 to raise your hand, *6 to unmute if you're on the phone, and if you're in the Zoom room already and wish to participate, please raise your Zoom hand, which is the hand on the bottom of your screen. Once you are permitted in, you will have 3 minutes to discuss. I don't see anybody hands raised yet.
Okay.
Not yet. Okay, I don't see anyone.
All right. So I want to make a motion to close. We will try to schedule this again sometime in January or February, based on our calendar.
So
That
the
works.
motion, okay, sorry. The motion to close, Vice Chair Chanda? I'm sorry, Alexia is speaking?
No?
Oh, okay, I heard some voices, I'm sorry. Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Aye.
Okay. Item number, thank you. Item number 30, 584-82BZ, 200 East 64th Street, Manhattan. Is this you also, Alexia?
It is not.
Okay. This is Amanda? Who's this?
I think it was
Fayan,
Amanda.
Fayan.
Oh, okay.
I'm actually going to get off until Dunton Avenue.
Okay. Okay, raise your right hand, Fayan. Miss Baton, I'm sorry.
That's okay. Let me just say Michael Dimson and Michael Schmidt are also part of the team, just in case there are any questions.
Michael Dimson.
Mike.
And other names, please.
Michael Schmidt and Michael Dimson.
Okay, Michael Schmidt. Okay, those gentlemen are complaining. You want to unmute, please, and put your videos on? Thank you, Mr. Schmidt. Mr. Dimson?
Okay, I got unmuted. Let me see if I can get the video. Oh, that work? There we go.
There we go. Nice to see everyone. Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Yes.
Yes.
Okay, please proceed, Ms. Baton.
All right, thank you. So hi, I'm Fan Baton from Sheldon Lobel PC for the applicant. We attended today's review session. We thank you, board, for the comments. The applicant team worked really hard in addressing the board's concerns, and we're happy to hear that the board appreciates these efforts and revisions. I understand that there are not many outstanding issues, just some outstanding questions, which I'm happy to respond to. The first regarding DCP review, I mean, while it's technically a POPs location, it's been under the BSA's jurisdiction as a variance since 1985. So we don't believe it's necessary for DCP to review, as the board has already granted waivers for the plaza. I looked over the prior resolution and it did not defer to city planning, and I can't find anything like a CPC report. So we believe it's been on solely under BSA jurisdiction because it is a variant application. That's regarding DCP. Regarding any outstanding fines, I think it was mentioned in the prior submission, but there are no outstanding ECB fines. I think actually something was actually overpaid, so no outstanding fines as of right now, if you look at the BIS website. And then I think regarding the timeline and the time frame, it really depends on local law 11 requirements for facade inspection and repairs. So the building's local law 11 report is due in 2023. So inspections will happen and work will be done throughout 2023, which includes scaffolding. So only once that's completed, the work on the plaza can start. So hopefully that'll be the end of 2023, early 2024, but it's unclear and totally dependent on local law 11, especially since it will be scaffolded while there'll be the inspection of the facade. However, the ownership already has the funds to start the project, so it's less of an issue regarding the funds and more regarding how long it takes for DOB to handle the local law 11 issues. And
do you need to submit any revised plans to DOB to get a permit to improve the plaza?
For the local law
To answer
11?
that for you,
Sorry, can you repeat?
Yes.
Is it local law 11 or for the?
No, not local law 11, to the plaza, to modify the plaza. Do you need to submit the plans to Department of Buildings and secure a permit to amend the plaza? That was the question.
I can answer that, Fayan. Yes, we have a submission to the Department of Buildings. We received an objection that we had that we were required to get BSA approval for the redesign of the plaza. Once we have that approval, we intend to submit, now that we have the final design, we intend to submit the plans back to DOB in the open application for final review and approval.
Okay. Okay. And they will issue a work permit. I'm assuming you'll need a work permit, therefore, to do the work.
Yes, a work permit. The process is the only objections we got were objections for BSA approval. Now we'll have to, once we get that approval, we can submit back to the DOB with the final set of plans. They will approve those plans. Once they approve those plans, then the contractor that's doing the work will request, and the DOB will issue a work permit.
Do you have a contractor lined up to do the work?
Michael?
We don't have, we've bid the job, but as we were unsure whether it was going to be approved, we do not have final bids. It'll be multiple contractors under the direction of the ownership.
Okay.
But we have reached out to all the different trades that would be necessary to do the work.
I mean, the reason I'm asking all these questions, it's because I want to, but I do believe the applicant wants to improve the plaza, but I want to make sure that there is a momentum and that effort is underway. And so what I would want from you to provide a letter kind of stating that I understand the local law 11 that prevents you from doing any improvements now, but there is a lot of behind the scene work that you would have to do while the local law 11 is happening, which is getting the drawings approved by DOB, bidding it out, getting the contractors, all those timelines, so that if, should the local law finish in a timely manner, which almost always never does because of weather conditions and other issues, factoring that in, that you would be ready to start once the local law 11 is complete. So that is the reason why I'm asking for those questions. I do want a letter, and it needs to be a letter of affidavit from the property owner, who will basically state that they will be they have the commitment. These are the steps that will be undertaken, and this is the way the work is going to be done, and this is the projected timeline. Because based on that, I'm going to close and make a recommendation to. I'm going to close now, but but when we do approve it, those are the timelines that will be put as a condition.
That's not a problem. The plan is after we get approval from BSA, we will immediately get all our ducks in a row so that when we're able to start after local law 11 is finished, it will go right away. Like I said, the funds are available. It's not a matter of funds. It's really just a matter of getting the local law 11 work done. And as you said, that's sometimes out of our control as far as permitting and weather and everything else. So we want to get it done as quickly as possible because no one wants a scaffold around the building. But like I said, we're at mercy a little bit of the city on that.
Yeah. Well, I do want to thank you all for, you really did a very good design. The team did a very good design, a thoughtful design. And I appreciate the fact that you figured out a way to level the plazas. That really changes the dynamic of the operation and the use of the plaza and makes it a lot more accessible and open also. So I think it's a great design. I wish you all the success and good luck with local law 11. So any questions or comments from the commissioners? All right, let's go to the public.
So the case we're currently discussing is 5A482BZ 200 East 64th Street, Manhattan. This is an amendment of a previously approved variance to modify the layout of a privately owned public space known as POPs. Should you wish to discuss, dial 646-558-8656, or if you're outside the city, 888-475-4499. You will enter webinar ID number 875-1461-9752 and press the pound sign. Once you are, at the next prompt, you will press the pound sign. Once you're in, you'll press *9 to raise your hand, *6 to unmute if you are on the phone. Once you are in, you will be given 3 minutes to speak. Let's see, anybody raise their hand?
How much time will you need, Ms. Batanfood, to get the letter with all the things? One is confirming that the financing in place, given the local law 11, the work cannot proceed, but in the meantime, all the various steps that would be undertaken to secure the DOB permit, getting the bids, and an approximate timeline of when the construction will start.
I'll refer to Michael Dimson. Do you think we could get this done within a week or two?
I don't see why not. I mean, we intend to do all those things. It's a matter of drafting it and getting it out to them.
Okay, thank you. We don't have any meeting in December. This is the last one. So we will schedule it for January or February, whenever, based on our hearing calendar.
Okay, and we'll submit the letter as soon as it's ready.
Okay, somebody from our office will confirm when we are going to schedule it. So,
perfect.
Do you wish to close, Vice Chair?
Yes, I do want to make a recommendation to close. And again, really, really, really thank you. You guys did come up with a good design solution. Wish you all the best. Thank you.
Thank you.
So a motion to close, Vice Chair?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Aye.
Okay. Next item number 31, 303-12BZ, 1106, 1108 Utica Avenue, Brooklyn.
I think this is Elise.
Yeah, it's always.
Hi, how are you?
Good morning. Sorry, good afternoon. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do. Thank you very much. Elise Fullader from Eric Palatnik PC. Spoke with the owner's representative, and we just want to thank you so much for your comments. Really appreciate them.
Great, thank you. Any questions or comments from the commissioners? All right, none. They seem to have no questions. We are satisfied. Go to the public, please.
The case we are currently discussing is 303-12BZ 1106-1108 Utica Avenue, Brooklyn. This is an extension of time to complete construction for the development of a 3-story community facility house of worship. Should you wish to discuss, please dial 646-558-8656 or our toll-free number if you're outside the city, 888-475-4499. You will enter the webinar ID number 875-1461-9752 #. At the next prompt, you will press only the pound sign. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute if you are on the phone. If you're in the Zoom room already and wish to discuss, please raise your hand, Zoom hand, which is a small hand, at the bottom of your screen. Once you are permitted in, you will have 3 minutes to discuss.
We okay.
Okay.
Right. No submission is required on this one. We are all satisfied. You can give us an update though if the sidewalk repair is done prior
Sounds
to the vote.
good. Okay, no problem. I will ask them whenever I find out the submission date.
So we're actually getting a submission then, right?
Right.
Maybe.
Yeah. Well, you know what? Let me change it. Yes, I
Okay.
do want a letter from you.
Okay, no problem.
Stating when the repair of the sidewalk is going to happen.
Okay, no problem. I'll ask.
Now that it's opened up, it's at a greater risk of somebody stumbling and falling, especially if the snow falls and everything. It's not going to be good. So I do not want to close that book without recognizing that. So do provide a letter providing an update on the sidewalk repair status.
Sounds good.
Okay. Do you wish to close, Madam Vice Chair?
Yes. Yes. Yes.
Okay. So the motion to close, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta, Commissioner
Aye.
Shabeta,
Aye.
Commissioner Yoon.
Aye.
Okay.
All right. Thank you.
Thank
Okay.
you.
New cases.
Let's
item
take a
number-
break.
I was just going to ask you.
Hold on. Yeah, let's take a break. Let's take a lunch break. All right, because this is, and we'll just take this all the way till the end after that. So let's, how much, typically what we do, 30 or 45 minutes?
45.
Yes.
Yeah.
I'm
Go
sorry.
ahead.
45, okay, 45 minutes. So it's 12:35. Forty-five minutes from then.
We'll resume at 1:20. Okay.
Okay, put the brakes on up. Thank you.
I'm here. Okay. It's what's 120? Okay. Okay, ladies and gentlemen, we are back on the record. This is the Board of Standards and Appeals public hearing for December 5th, 2022. The next item is new cases. Item number 32, 16008BZ, 651, 671 Fountain Avenue, Brooklyn. This is Mr. Dale. Okay.
Hi, good afternoon.
Good afternoon. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to the board member questions?
I do so affirm. A lot of excitement for that after lunch, Tony.
Caffeine, man.
There you go. Good afternoon, Todd Dale, for the applicant for this matter. I did listen to review session and heard comments that were raised by the board. I will speak to those comments and hope to make myself available to answer any additional questions that might be raised. The first thing I would say is just to confirm, and I think that this, as was stated, this is an application for a re-argument based on misapprehension of facts or misapplication of controlling principles of law. It's not an application that's seeking a determination on the extension of time or amendment of the variance. We realize that it's more of a procedural application than a factual application. That noted, we will reference facts only as they pertain to the re-argument issue that's before the board. We'll focus on those issues. And I believe that once we set forth the misapprehension of fact argument and the misapplication of controlling principle of laws argument, that it would be appropriate to schedule the application that was dismissed, put it back on the calendar for re-argument. First, I'd like to speak to misapprehension of the facts and focus on some key items. The first thing that I would want to note is that, there were the 5 conditions that were in the original resolution that were referenced as the implementation schedule. And I just want to confirm, because it was not noted at any of the hearings or in the resolution that was issued by the board. But the fact is there were 5 conditions that were set forth. And the fact is all 5 were met. 3 were timely, 2 were late, and we acknowledge that they were late. But the fact is all 5 were met. And I think it's important to distinguish between those conditions that are noted with the fact of what the current site condition is. We noted that the current site condition was not satisfactory and needed improvement, but the current site condition is distinct from those conditions that were set forth in that implementation schedule, those 5 conditions. Now, speaking to those 5 conditions, just to confirm, just generally there were 5. The first one that was set forth was the hours of operation, parking, and circulation needed to be changed upon grant of the resolution. And the fact is that that did occur. The second was that removal of the second story of a shed and painting needed to occur by September 15th, 2010. That is after the grant. The grant of that application was July 2010. And that did occur. There was a requirement that sidewalks and tree planting be completed by April 15th, 2011. That did occur. However, as noted, it took additional time to receive the approval from the Parks Department because the original proposal that was set forth, the Parks Department did not like or was not willing to approve the continuous tree band that was originally shown. So the plans were altered to satisfy the Parks Department, and that was completed pursuant to the grant. But as noted, it did occur after the April 2011 deadline that was set forth in the condition. There was a requirement that fencing be installed by May 2011. That was installed. And then there was a requirement that landscaping and street trees done by July 2011. And as related, that one was done late because of the delay in retaining a setup that was approved by the Parks Department. The fact is, all 5 of those conditions were met and were satisfied, and they are distinct from the condition of the site. So if the board is to set forth that these are conditions precedent or conditions related to the grant of the variance, I think it was important for the board at the most recent hearing to explain why those conditions were not met if in fact the board determined that they were not met. The board has heard many, many cases, some our office has prosecuted, some that other applicants have prosecuted, where there's been applications for extension of time or amendments where conditions were met after a deadline. And the board appropriately reviewed those, determined the significance of the delay, and would set forth new conditions or additional requirements for meeting these conditions if they were not met by a very specific deadline. So it is not without precedent that the board has heard applications for extension of time or re-argument where conditions were met, albeit late. But I just think it's very, very important to note that all 5 of those conditions were in fact met, 3 of them, in fact, by the time frame that was set forth. Related to these conditions, and this is discussion that the vice chair brought up during her comments during review session, I think it's important to set forth that the board in its most recent resolution, the dismissal resolution, set forth that there were conditions, that these were conditions precedent as opposed to conditions subsequent. But the fact is that is going to be shown to be impossible, that they were conditions precedent just based on the fact of the conditions themselves. Of those conditions, 4 of those conditions had timeframes that were set forth after the grant of the resolution. The resolution was granted July 13th, 2010, and 4 of those conditions had timeframes for completion of September 2010, April 2011, May 2011, and July 2011. It is literally impossible to consider those conditions precedent if the timeframe for completion was after the board granted the variance. What would have been possible for the board to do was to set forth a schedule for compliance hearing, which they've done even on today's calendar, or set forth a compliance schedule for submission afterwards related to the variance. But it is impossible by those timeframes to consider those conditions precedent as opposed to conditions subsequent. And finally, I would just note from a misapprehension of facts point that the resolution was granted. It is clear language in the operative clause where the board notes that all of the findings were met. The implementation clause that's referenced with these implementation of the conditions, that's discussion, it's not operative. And if there's a conflict between the discussion in the body of the resolution and the operative clause, it would follow that the operative clause would control. And the board restated in the operative clause with the resolution all these conditions set forth again. And the board had the opportunity to conduct compliance hearings. There are other agencies that could have gone and issued violations. As we noted, no violations were ever issued at the property, no compliance hearings were there, and there was never any notice set forth with respect to the variance, and no reasonable understanding that the variance would never have been granted in the first place when there was a written resolution issued by the board in July 2010 with the undisputable plain language saying that the board grants a variance. So with respect to misapprehension of facts generally as applied to the resolution, we would state that it is a misapprehension and erroneous reading of the resolution to say that the board does not have jurisdiction, that it never granted a variance. The combination of facts show that the fact that the board did in fact grant a variance, did set forth conditions subsequent to the grant of that variance. And, you know, if the board wants to review those conditions or review them with respect to the request of the extension of time or amendment, that is fully within the board's power. We don't dispute that. And we also understand that, you know, pending the resolution of this particular re-argument hearing, that the board may still raise issues or have concerns about those conditions or set forth new conditions of compliance, but it is without precedent and without substance to say that the variance wasn't granted. And I would just note just quickly on that, I would ask the board to consider the fact that if in fact there were variances that were granted by the board that would be considered that they were never granted in the first place, to consider the chaos and the havoc it would wreak on the for property owners in the real estate market in this city if there were no assurances or no clear time frame set forth for review of conditions or revocation, and no notice of hearing for potential revocation of a variance. So that's my initial comments with respect to misapprehension of facts. Moving on to the misapplication of law, I would note that, and this follows up some of the discussion that happened during the review session, Section 7221 sets forth that the board must set forth each required finding for a grant or a denial of a variance. In the original resolution, the board set forth those findings for the variance grant only. If in fact that variance were not granted, logically it would follow that the variance application must have been denied. And 7221 requires that if a variance application is denied, the board must set forth each required finding as a reason for the denial. That original resolution in 2010 issues no such findings for denial. So again, going back to just a pure procedural point with respect to the law, 7221 requires clear findings specifically be set forth. They were never set forth. The only findings that was set forth for the grant. And then with respect to 7022, which is the section that pertains to conditions, this very clearly says that the board can set forth conditions or restrictions applying to the grant of a variance. During review session, the vice chair noted that the majority in denial from the most recent application found that these were conditions for. And the fact is that there's nothing in the zoning resolution that sets forth a power or authority to the board to set forth conditions for the grant of the variance. Any such conditions are in fact the findings themselves. So the board has the power under 7022 to set conditions, subsequent conditions to the grant of the variance, but anything that's prior to the grant or for the grant is the findings themselves. And that goes hand in hand with 7221, which requires the specification of those findings. You know, it just goes to the whole point that these are very clearly based both on the zoning resolution and past practice of the board, that these are conditions subsequent and not conditions precedent. The board has the power, as we noted, to conduct compliance hearings or to set a matter for revocation of a variance, but those matters then need to go on the calendar, go through proper notification procedures, notifying both the neighborhood and the property owner themselves, and that never occurred in this particular case. The findings for the denial were just never set forth in that original application. And then the last thing that I would state before I'm happy to answer any questions or discuss is I would just note, as I said, that the compliance requires a revocation hearing pursuant to the board's rules 1-07.1 subsection 5, which never occurred. And those findings are to be specifically set forth. They were never set forth in a hearing or in the original resolution. Based on those reasons, we find that a new hearing would be appropriate and also required based on pertinent statute. This new hearing would allow the board to review the application and the proposed development. Oh, sorry, I have YouTube going in the background. I apologize for that. So a new hearing would allow the board to review the application and their proposed development. It would afford the board opportunity to ask questions about the development of the site that were not reached initially based on this jurisdictional determination. And then the board would then have the opportunity to either set forth requirements and a strict compliance schedule, in addition, additional conditions, shorter term, or many of the mechanisms the board use, or the board would then could deny the application, but set forth the specific findings for that denial, providing the property owner with a clear determination, and also setting it forth those findings that would afford the property owner the opportunity to seek relief from the court should he or she choose. The jurisdictional determination does neither of that, and for that reason, it's very appropriate to have the new hearing scheduled, at which point either of those paths could be followed. With those items set forth, I'm happy now to, discuss any particular issues further as the board sees fit.
Vice Chair, you're muted.
Oh, sorry. Thank you. I don't have any questions or comments. I think what I stated is pretty clear, and I don't want to add any more information to that. Are there any questions or comments from any of the other commissioners? Okay. All right. None. Nobody has any questions, comments. I guess whatever we have stated holds. Should we open this up to public?
Yes.
Yes. Okay.
Okay. So the case we are currently discussing is 16008BZ. Steve, you want to put the screen up? 651, 671 Fountain Avenue, Brooklyn. This is an application for re-argument of an application dismissed on April 11th, 2022, under the board's rules of practice and procedure. Should you wish to discuss 646-558-8656, or if you're out of the city line, toll-free number is 888-475-4499. You will enter the webinar ID number 875-1461-9752 and press the pound sign. At the next prompt, you will press the pound sign only. Once you are allowed in, you'll press *9 to raise your hand, *6 to unmute to speak. And if you're in the Zoom room already and wish to discuss this application on Fountain Avenue, please raise your Zoom hand. I don't see anybody raising a Zoom hand. No. Once you're allowed in, you'll have 3 minutes to speak.
Okay. All right. Thank you, Mr. Dale, for your statement. I'm going to make a motion to close.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
We will schedule this and we'll let you know as soon as possible. Can't hear you.
We can't hear you, Todd.
Can't hear you.
Let's just give him a second.
Yeah.
Sure.
Now,
Yes.
You're
Okay.
back. Thank you.
there must be something wrong with the headphones. We'll lose the headphones. I would just like confirmation that we would like to make a written submission supplementing what was stated verbally at the hearing today. Just confirm the record's open for a written submission.
Sure.
Okay, thank you.
Thank you.
Okay, moving on.
Yes.
Moving on, item number 33, 2017-232A, 1632 Richmond Terrace, Staten Island.
Who is?
This is Robert Scarano, and I don't know who else.
Hello.
Yeah, do you want to visual, Rob, as a panelist?
Yeah, I'm having a little problem with the phone. I'll try to see if I can get it on, but I don't know. I'm having a little issue with the phone.
Okay,
I don't-
is there someone else? You have an associate in the room also? I see this pitch on the picture.
Serranos.
Yeah, we have three people attending this hearing named Robert Scarano. If you would please rename yourself appropriately in Zoom. Thank you.
Well, that's Bob. So that's Robert Scarano. Who's the other gentleman in the blue shirt, blue jacket?
Can you hear me? This is Ben Alcorn. I'm from the ownership.
Ben Alcor?
Yes.
Okay, thank you. Thank you for changing the name. All right. Anyone else?
Anyone else, Mr. Scarano?
Is that Ilana might be from my office, my manager? She might be on remotely also.
Does she need, is she going to make a statement? Does she need to be sworn in?
She's just observing.
Okay. There's Alana.
Hello, everybody.
Hi. Okay, Mr. Scarano, do you want to start? You don't have to be sworn in. It's an A case. It's an appeals case.
Yes. So
Okay, you heard the board's comments.
Yes, we were listening this morning to the review session, and all of those particular items will be answered and submitted. I want to just state for the record that the building has been completed according to the board's action and the fire department and other issues that were raised. We have actually obtained actually all of the required sign-offs from the various agents of the city, including for our sprinklers, fire alarm system, construction, plumbing, elevators, electric, signage, and whatnot. And unfortunately, due to the delays that were incurred when we were not allowed to work during the pandemic, we lost approximately a year and a half in our construction schedule, which had us miss the completion by literally a month or two.
Okay, all right. And the DEP also, I'm assuming you have everything?
Yes, the DEP has also signed off. We had, as part of our action, we had a relocation of a fire hydrant, which was filed, permitted, and signed off. We also brought in all new street connections, which have to do with the DEP. Those street connections and the plumbing and sprinkler were all signed off. We brought in new water mains. Everything was completed. As it was mentioned, the only drawing that we will resubmit is the site plan that the board approved when they were doing the original case.
Okay, all right, great. Yeah, I think we just need that to make sure that everything has been built pursuant to what was approved. That's really the intent of it. So any questions or comments from the commissioners? Chief Daly, do you have anything to add to it? I'm sorry, you can, I'll get back to you
Unmute.
later. I'll get back to you
Unmute.
later. Let's
The
go to
fire
the
department
public.
is satisfied? I'm sorry, Madam Chair. The fire department is satisfied with this application. You see, they have all their sign offs, and as a matter of fact, an inspector is going to be stopping by the building to create a sprinkler and standpipe accounts to test the system in 5 years. I did check our record. The fire alarm system has been signed off by our fire alarm inspection unit. So thank you very much.
Great, thank you. That's good news. Any other questions or comments? All right, let's then go to the public.
Sure. The case we're currently discussing is 2017 232A 1632 Richmond Terrace, Staten Island. This is an extension of time to obtain a certificate of occupancy or previously approved general city law section 36 for a self-storage building. Should you wish to discuss, dial 646-558-8656, or our toll-free number should you be outside the city, 888-475-4499. Enter the webinar ID number 875-1461-9752. Press the pound sign. At the next prompt, you will press the pound sign. Once you're in the Zoom room, press *9 to raise your hand, *6 to unmute to speak if you are on the phone. And if you're in the Zoom room already and wish to discuss this application, please raise your Zoom hand, which is the little hand that is in the bottom of your screen. Once you are permitted in, you will have 3 minutes to discuss the case.
Mr. Scarano, how long will it take you to make these submissions?
We will be able to resubmit thing within the next few days. There is nothing onerous about what you asked for, and we have that all ready at hand. I would like to also just state again, even though it was stated by one of the commissioners, we don't have any open violations on the property at this time as well. And if you review the required items checklist on the Department of Buildings computer, you will see that there are only 3 items that are left for us to obtain our final certificate of occupancy, which we had hoped we would get before the end of the year, which helps us with the tax abatement. But under the circumstances with the hearings, we may end up having to get it after the end of the year, which is unfortunate, but it's inevitable. But yeah, that's pretty much the extent of where we are. And we're ready to submit this week.
Okay. Well, the earliest hearing we can schedule you for, it will be early January. That's our next hearing. It's, I think, January 9th or something like that.
January 9th.
That would be fine.
Yeah. Okay, so please submit it as soon as possible. I think, I just want to go to the calendar and see the submission for January 9th is December 21st. So make all your submissions prior to that.
We will. And as expected, we would be able to probably close all this out sometime around 90 to 120 days after that or less, but as an outside date.
Okay.
Do you want to close this, Vice Chair?
All right. Yes, I do want to make a motion to close. And we'll schedule it for January 9th vote decision.
Okay. Motion to close, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Okay. So you want this for January?
Thank you.
Thank you. So we'll get back to you. We'll get back to you with the schedule.
Thank you, Tony. Thank you, everyone, and good afternoon.
Good afternoon. Okay, next item number 34, 2017-306BZ, 1977 East 14th Street, Brooklyn.
Okay, I think this is Miss Altman.
Yeah. She's there. Go. Okay. Hi. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Of course.
Okay. You heard the board's comments?
We did. Good afternoon, Lara Altman from the Law Office of Lara Altman. We did attend your executive session this morning. We heard your comments. Thank you for your positive feedback. With respect to the extension, I have spoken with the client and with the architect, and we've decided that we do want to pursue an extension as well. We don't think we're going to be ready in time, and instead of making it a separate application, we'd rather roll it into this one.
So you will add extension of time to this application.
That's correct.
That's
We
what
can
I'm-
do that relatively quickly as well.
So this will be an amendment to the application, current application?
We're going to modify the current application to include an extension of time to obtain a CO, correct?
Great.
And no
Carl,
objection
does
to be
the-
required, so we can have that done in just a couple of weeks.
Yeah, we'll pay a separate fee.
Of course.
Yeah, and I'm sorry, Ms. Altman, the filing for the extension of time is timely, correct? Or is it require a waiver?
Well, our time is told until March of 2024
Very good, thank you.
because of the, as Chase had said earlier, because of the pandemic.
Very good, so just a straight extension of time.
Correct.
And just to add, technically, given the executive order or the import of the executive order, it would be more than a year before, but given that the board's condition, it would be within a year or 30 days after that. It would be, we will accept it as timely and no waiver will be required.
Thank you. I appreciate that.
Okay.
Great. So I guess we will then keep this item open since this will be amended and as soon as you submit it. Do you have to again go through a community notification? No, no extension of time. You don't
No,
need
extension of times don't.
As a courtesy,
No,
I
you
will
don't
let the
need to.
community board know, but I don't anticipate any problems.
Okay. Right. Okay. All righty. Thank you. Any other questions or comments from the commissioners?
Okay.
None? Great. Let's go to the public.
The case we're currently discussing is 2017-306BZ, 1977 East 14th Street, Brooklyn. Should you wish to discuss, this is an amendment of a special permit for a single-family home enlargement. Dial 558-8656, or toll-free number, should you be outside the city, is 888-475-4499. You will enter the webinar ID number 875-1461-9752 and the pound sign. At the next prompt, you will press the pound sign. Once you are in, you press *9 to raise your hand, *6 to unmute if you are on the phone. And if you are in the Zoom room already, please raise your Zoom hand, which is the Zoom hand, the little hand that is in the bottom of your screen. Once you are permitted in, you will have 3 minutes to discuss the application.
Ms. Altman, how long will it take for you to file the extension of time application?
We should
Or
be able to
amend?
get this in to you, I would say, before Christmas. Because I know that's when a lot of people are out for that following week, but we should be able to get it in before that week.
Okay, all right. We'll get back to you as to when it's going to be rescheduled.
Thank you.
Most likely it's going to be probably March or February.
If we could do it earlier than March, I'd appreciate that. I know the client is anxious to begin construction in the spring. So if it would be possible to get it in the end of January or in February, early February, we truly appreciate that.
Okay, the woman is up. I haven't seen any hands.
Okay. Thank you, Ms. Altman.
Thank you very much.
Okay, so we'll continue that. Appeals calendar, continued hearing items. Item number 35, 2018-188A and 189A, 194-28 and 194-32 Dunton Avenue, Queens. This is Alexia Landsman.
Okay.
Hello again.
Hi. This is an A case. You don't have to be sworn in, Alexia. Please proceed.
So we have attended the executive session, and I just want to reiterate that what's stated in the submission that we had submitted last week. The owner is making efforts to clear the site, and as of November 15th, there was a partial the stop work order on the site was partially rescinded. I know that there was some misunderstanding as far as the DEP comments. Tony has relayed to me that she has reached out to DEP, and they are not willing to change their comments until the GCL 36 application is withdrawn. And in order to do that, we need to get the sign off from the fire department, and we need to clear the site, which is what the owner is currently working on. There's a question with regards to the building pavers plan. And the reason that's an issue for us is because there are two separate sites. The owner retained a new architect for Dunton Avenue, but Palermo Street is not her project. And so she can't actually file a builder's payment plan for that site, as she's not retained to work on it. So we're just trying to hopefully get the GCL 36 waiver withdrawn with the BSA, and hopefully the DEP will then revise their comments to just reflect Dunton Avenue instead of Palermo Street.
I'm just trying to find out the sequencing of it. So DEP will not issue anything until the GCL 36 is withdrawn. Is that what it is? And
Tony, can you chime in on this? I actually haven't spoken to DEP directly. Tony has been.
No. DEP is still looking for you to respond to their comments. Right. DOT was questioning what happened to the GCL 36 because they looked at the entire project, and I said you were withdrawing that because you were complying, so that was no longer in front of the board. So we sent them the revised plans as the last submission, and we still have not received any comments.
So the issue we're ultimately having is, in order for us to respond to all of DEP's comments, we need to file a builder's pavement plan for.
Right. Sorry. Thank you.
Unfortunately, the architect that we have on this case is not retained to work on Palermo Street and has no access to the plans for that site. So it's a little bit of a catch-22 that we're trying to work through. So we're hopeful that we can get the GCL 36 matter withdrawn, and hopefully then DEP would maybe revise their plans.
So all the comment, sorry, Ms. Landsman, all the comments that DEP has are all related to GCL 36?
To the site.
It's both sites. Originally, there was Palermo Street and Dunton Avenue. And so they want a builder's pavement plan for both to cover Palermo Street. Unfortunately, our architect is not the architect on that matter.
Yeah, I don't know how to resolve that.
But yeah, I'm sorry, I'm being very, so there is a need to do a builder's pavement plan for the Dunton site, right?
Yes, but right now, so originally there was a builder's pavement plan already submitted to DEP. This was a while ago. They want a new version of the one for Palermo Street. Unfortunately, we can't provide that. And since we've initially filed, we've actually withdrawn that application entirely, and we don't even want anything to do with Palermo Street. However, the fire department needs to sign off, right? So Chief John Daly has requested this to be part of the application. So we're having a little bit of an issue as far as how to go about addressing DEP's comments, despite the fact that we don't have the architect to provide this builder plan.
Okay. All right. So there are a lot of moving pieces.
Exactly. So we are
Um,
where I was told by the ownership that they are looking to clear the site in the next few months. And once that happens, I will notify the board with a new submission. So hopefully we can move this along.
So let's say by end of February, site will be cleared.
I'm hoping, yes. So can definitely schedule.
Okay, once the site is cleared, then FDNY, if FDNY is satisfied, will then sign off on what?
It's my understanding on the withdrawal, but I see that Chief John Daly has his hand up.
Okay.
Okay.
Yeah.
But isn't it also about the ownership too, John?
Okay.
Chief Daly, sorry.
So it's okay. Madam Chair, in addition to clearing the site, so in the event we have to access that the former hospital, those buildings, there are several wings in that building. It has a standpipe and a sprinkler. Now, the last time I went to that building, it was abandoned. Windows were broken and openings. There was a lot of graffiti. I was not able to get in. I wanted to take a chance for my safety. But not only do we need the site cleared, but is the standpipe and is the sprinkler system working? I personally believe that it's out of service, and that when we do go there, and if they are out of service, my order to the administrative company and to Borough Command would be to let the building burn, and to prevent it from spreading to adjacent properties. I mean, that's how bad I think this building, that the former hospital, has not been maintained for many years. I mean, it's something the current owner of that property should have done, and to pass that off to a new owner, I believe it's unfair. But we do have 2 violation orders outstanding, and when they do their due diligence, the proposed new owner, it should show up. So I mean, I'm very concerned. The system has never been maintained for many years, and it's practically a very dense area, and of course it's very hilly for our members. So I'm concerned. Of course, the new building, fire spreading there to the new house development, and also to the existing homes around that area, the hospital.
Thank you.
The access, but also the standpipe and sprinkler that we're concerned about.
I think at the last hearing, what we were targeting towards was providing access to the site. That was the main thing, because the site is under, and I think that's a question I have for Ms. Landesman, is what is the status of the ownership change?
So they're still looking to set up a closing date. I think that they're still negotiating who's going to be handling hearing the site violations. I mean, the site, obviously, as Chief Daly had mentioned, needs some work. And I think that they're just internally trying to figure out who's going to be assigned the responsibility. There hasn't been any updates as of yet, but I know that the ownership is trying to clear the site as per our latest hearing. And so that's what we're focused on now. At this time, I don't have any other updates other than ownership is working on it. And I'm hopeful that maybe by end of February, we will have a better update for you.
I think but I really don't want BSA 2 and the BSA action that is before us to be driving this, but just in terms of liability and other things, right now, your client has the ownership. And I think just in terms of any possible issues that may arise, it's in your best interest to ensure nothing untoward happens that affects your ownership liability. So that's just something I'm going to state, but it's not something I'm going to require, or because with the changes to ownership, it's the ownership, new owner takes it with the full understanding and responsibility. But in the meantime, this is an issue. And so in the best interest of everything, it would be ideal to have it resolved now. Then you can move forward with all of the things as quickly as possible, and put everybody at peace. You know, that's just a Christmas holiday, good feeling, good vibe, thought kind of coming my way, from my way. Okay, so now in order for FDNY to sign off on the builder's pavement plan, what is it that NYPD needs other than clearing of the site? And
I think the question is, we need to get the GCL 36 waiver application dismissed.
Right, but how do you do that? That's really what I'm trying to understand. How would you get the waiver dismissed? Who do you? I'm trying to piece together this information. Is how I know you want to get this withdrawn, and we are okay with it, but you also have the ownership issue. So I'm not comfortable approving it, allowing a withdrawal until the ownership title has changed, and you can prove that. And I don't want the change of ownership title as a way to drag on this whole process and make the site risky either.
Okay. I'm going to relay to the ownership that they have to fix the site or they need to change ownership. It's one way or another. The withdrawal is centered around that. And then once that's dismissed, I'm hoping that DEP can issue revised comments that just pertain to Dunton Avenue.
And DOT.
DOT, sorry, DOT. Has DEP?
No.
Okay, so I guess we're just waiting for DEP to respond. We don't even know what their comments are as of yet. But from my understanding, when I took over this case, the Dunton Avenue property had no outstanding comments from the board. So it really is just hinging on this Palermo Street property. And so we're working on that to resolve that.
Okay. Yeah. So once you remove the Palermo, are you working towards the BPP for the Dunton sites at least?
Well, the architect would be able to file a revised BPP plan because she's retained to work on those properties.
Okay. And basically it's ready. It just, you need to file it once the GCL 36 is big. Okay.
That's correct. Exactly. Yeah.
All right. Any questions or comments from the commissioners? None? I see nobody has any questions. Let's go to the public.
So the case we are currently discussing is 2018 188A and 1889 is 19428, 19432 Dunton Avenue, Queens. This is construction of a two-story single-family detached building seeking waivers of the general city law section 35, building in the bed of the map street. If you wish to discuss, dial 646-558-8656 or our toll-free number should you be outside the city, 888-475-4499. Enter webinar ID number 875-1461-9752. Press the pound sign. At the next prompt, you will press the pound sign only. Once you are in, you will press *9 to raise your hand, *6 to unmute if you are on the phone. And if you are in the Zoom room already and wish to speak, please raise your Zoom hand, which is a small hand on the bottom of your screen. Once you are permitted in, you will have 3 minutes to speak. You can raise your Zoom hand if anyone wants to speak. I know there's neighbors in the room, so I don't know if they're going to speak.
All right, Ms. Huntsman, what is the timeline that you can give me as to when you're going to have the site? You said February, the site will be cleared. Ownership, still in negotiation.
I would like to suggest end of February or beginning of March if possible. I will discuss with ownership and I will relay how urgent this is and that they need to get this addressed one way or the other.
Yeah, I think the delay is kind of created at your end. Don't drag the ownership because I won't let the withdrawal of GCL 36 without the change in ownership.
Okay, I'll relay that.
So I don't know, there's a call-in number 028, but no one's raised their hand. So I don't know if that call-in number, it's a 516, last 3 digits 028, if they're calling into that case. I don't know. What to say. Are you letting them in? I don't know. There's nobody raising their hands. If that person who has last 3 digits 028 is calling regarding Johnson Avenue, please unmute. Otherwise, we'll go on to the next case. Does anyone wish to speak again on Dunton Avenue? I know that there are some neighbors in the room. Do they wish to speak or not? Please raise your Zoom hand. And the person who's dialing in 028, should you unmute, please? *6 to unmute. Nope.
Do we have
There's no one raising their hands, but someone's called in as 028. 516, the last 3 digits are 028. I don't know. Oh. Hold on, hello?
I have no comment, sorry.
And you are?
Okay.
I'm actually for the next case.
Oh, okay, for 38th Street?
Yes, ma'am.
Okay, we'll let you back in. Okay.
All right. So we will have to schedule this sometime. I would say we will try to do it end of March or April. That will give you enough time to get all the sign-offs and submission for end of March or April. Do we have a hearing at end of March? I just need to look at the schedule. End of March, April, those are the possible.
Okay.
Okay.
Yes, thank you very much.
But please, I urge you to have your applicant resolve this issue because that is delaying this whole process.
Yes, I will be firm with that.
And making the site more unsafe.
Understood.
Thank you.
Thank you. Have a great day.
Thank you, Alexia, for coming. Okay, last item, new cases, item number 2022, item number 36, 2022 62A, 34 West 38th Street, Manhattan. This is Paul Prue. Please let Paul Prue into the room. Please accept this panelist, Paul. Mr. Prue, sorry.
Good afternoon, Commissioners. Paul Prue here for the applicant. I also have that 0280 number is Byron Patel, who's representing ownership, and John Sharma should be dialing in also.
I don't see John yet.
I don't think there's any
028, and who is the 028 person?
That's Byron Patel. He is the owner.
Okay.
So we can go ahead without Sharma.
Okay, this is an 8 case, so you don't have to be sworn in, Mr. Prue. You can proceed.
Okay.
You heard the board's comments?
Yes, thank you. Good afternoon, everybody. We heard your comments. I'd just like to commend the team effort and note that the pictures that we submitted do tell a little bit of a story here. In December of 2018, when the hotel special permit law was passed, you have a set of pictures that show our construction site under construction. At that time, the partners who owned the 3 lots had purchased 2 of them, which had no building on them, was empty land, and they were in the process of building a foundation on that land. They were also building a foundation in the existing building, which had not been approved for demolition yet, and they were actually working inside the building on the first and lower levels. So those pictures do tell 1,000 words. The pictures starting on page 31 are dated the 21st, the effective date, December 20th, 2021, which is the effective date. And they show that the foundation for the entire proposed hotel and the first floor have been completed. So we're glad to hear, based on your comments this morning, that you believe that the findings have been met. And I'd just like to comment on a couple of the points that were made. I'd also like to point out that there's a companion case here with the statutory provision, and we would look to withdraw that. Community Board 5 did weigh in on that and responded positively to our application there. They did waive under the common law, but presumably their opinion remains similar. With regard to the construction costs, Commissioner Otley Brown, we appreciate your comments on the $906,000 amount that is indicated in our budget under loan closing, extension, and financial application fees. Those numbers, which summarize our soft costs of $4.8 million, include this $900,000 item, which is essentially advance payments on interest and advance payments on taxes, which were necessary to extend the land loan that was taken in May of 2017. And so I'm not quite clear on how you treat that, whether it should have been in the portion of our budget where we identified the land costs and the closing costs related to that 2017 and the 2018 closing, or whether the ongoing payment of those interest charges and real estate tax can be treated as a soft cost. But the conclusion either way is that you take it out of the budget and you take it out of the amount paid. And so the percentage of the soft costs paid relative to the total budget remains about the same. We identified about $5 million in soft costs that had been paid, with an additional $10 million left to go. So that was about a third. If you take 900 out of both of those, it remains about a third. So if you have any specific treatment for that or changes that are necessary, please let us know. But we think it should support the finding without change.
Yeah, my question was probably, I would have to say, more geared towards our legal team to first determine what were those fees towards. Was it towards the land loan or was it towards the construction loan? And whether or not that makes a difference in terms of counting it as a legitimate expenditure for the purposes of common law vested rights, because my point of view is that costs towards the land aren't necessarily costs in furtherance of this particular project. They could be applied to any type of project, whether it be the pre-zoning or a post-zoning project. And so my question was, does that mean that we shouldn't include it, or is it okay to include? So that's the question.
So factual clarification then for your counsel, the $906,000 was for the land, or it's in support of the land loan. So I think that if you were to take a conservative approach here and lump that in with the land costs, which we have isolated already, but that one slipped in, you would take it out of our budget and you would take it out of the amount paid. And so, it would not result in a net change, but certainly the question is relevant for both this case and others and for future applicants. So I'd be eager to hear your...
I would also like to find out. I think we have in the past discussed it. I also agree that if this is a cost associated with the specific construction and loan associated with specific construction that we are reviewing, then it makes sense to be included. If there are loans and interest associated with specific construction at hand, then it makes sense to be included. But if it is the general land value and the interests and loan associated with that, I don't believe it should be included, because should this project fail, I mean, you still have to pay that, and you can use it for any other project. So it should be eliminated just for, I mean, as you mentioned, Mr. Paggio, you can still meet the findings. It's just we need a clear record. So please correct that analysis. Just revise that analysis by taking that 960,000 off the soft cost, and then just revise the statement of facts accordingly, and that's that. It's just for a clear record.
Okay,
and I think
excellent.
Going forward, I would suggest to all the project managers and everybody, we keep that in mind, that any interest or loan associated with land, if we see that, ask for that clarification from the applicant if that is related to the land value or if that's related to the construction. And based on that, that should be counted or not counted, vice versa.
Okay, understood. So we will make a submission shortly to correct that error and bring the papers up to date. There were also some comments, Chair, that you and others had about the third finding and relating to substantial loss. And I would like to point out that we're not claiming any demolition costs on anything that has not been built, but we do believe that some of the foundation would need to be demolished in order to accommodate a major redesign for an as-of-right use. And so we do, I believe you recognize those as substantial and as costs that would apply. In addition to column spacing mentioned specifically by Commissioner Young, and the redesign costs that I think everybody agrees are appropriate here. And then I would just like to note as a bit of good news for the project anyways, we just closed on a new construction loan last month that takes out the existing debt and will apply to future construction at the site. So this site very much is ready to continue with your approval, and we thank you for your consideration.
Great. Okay. Any other questions or comments from the commissioners? None. Okay, let's go to the public.
Just one question. So you want a revised statement removing the $906,000, correct? And from the
Yes.
expenditure chart. Anything else? Anything about bolstering up the substantial loss? Serious loss? Serious loss, I'm sorry, serious loss?
I would actually suggest taking away that manufacturing use, because it's not realistic at all to assume a one-story warehouse in Manhattan. You have enough of an argument of a serious loss. So just take that manufacturing one-story warehouse from the equation and divert and basically what we stated in terms of all the other loss associated with having to refile, re-permit, drawings, retaining architects, engineers, everything to do all of that. So those are additional costs incurred and loss of all the investment that has been made towards this.
Understood.
I would say it's a redundant, Vice Chair. Like going to that option, the one-story manufacturing, it's a redundant. If an office building wouldn't work, definitely a light manufacturing, like 1 story or so, wouldn't work as well. So yeah, take it out.
Right, true, but we need them to construct the argument. That's all.
Right.
You're constructing the argument for the purpose of meeting the findings and helping us to create the resolution at the end. Even though instinctively we know that there is going to be a loss because there's a redesign, and there's a loss because, you know, everything that you filed, all your permits and fees have gone for naught, and you have to redo it again for another project. But you should still give us the narrative outlining that.
Understood. Commercial doesn't work, and neither would manufacturing, of course.
Well, I think what we are saying is don't even talk about the manufacturing warehouse, because the commercial is good enough. You have met your, I mean, and that's what Commissioner Shetta is saying, that if commercial doesn't work, manufacturing 1 story is not going to work. But I think don't even take it to the manufacturing, just talk about the commercial. And the fact that just converting this building to a commercial itself would be an enormous lift at your end, because you'll have to redo the plans, hire the engineer and architect to do all of those things, get the permits again. So you're losing valuable time, and all the efforts that has gone to waste.
Understood.
Yeah.
Very true.
Yeah. So just for that simplicity purposes, don't even talk about the manufacturing. That's what Commissioner Shetta was referring to.
Got it.
Just focus on the commercial.
Thank you, commissioners. Do you want to go to the public?
Yeah, yes, please.
The case we are currently discussing is 2022-62A, 34 West 38th Street, Manhattan. This is the common law vesting application for the owner to secure vested rights to complete construction of a development of a hotel prior to the adoption of a zoning text amendment. Should you wish to discuss, please dial 646-558-8656 or the toll-free number 888-475-4499. You will enter the webinar ID number 875-1461-9752 and press the pound sign. Once you are permitted in, the next prompt, I apologize, I'm talking ahead. Press pound sign at the next prompt. Once you are permitted in, press *9 to raise your hand, *6 to unmute if you are on the phone and able to speak. And if you're in the Zoom room already and wish to discuss, please raise your Zoom hand that is on the bottom of your screen. Once you are permitted in, you will have 3 minutes to discuss.
Okay. How long will it take you, for you to make these corrections?
We can have something out in a week.
All right. I mean, next hearing is in January, so you have till at least December. I mean, I'm hoping we can put you in for January hearing, but we have 2 dates in January, so we will get back to you. But you have, the first one is December 21st submission, and the next one is January 5th submission, just to give you an idea.
Okay, I think we can make the earliest of the 2 and hope that you can accommodate us at your earliest convenience.
We will get back to you. I don't have the full list in front of me to know how loaded we are. I believe we are, but
Okay.
Okay. All right.
All right. Do you
So
want to
try to put are we okay to close? Yeah, are we okay to close this application, commissioners? All right, let's close this, and then you have to submit those 2 information, revising the expenditure and revising the findings, the 3rd finding, which is a serious loss.
Understood.
And a revised statement of facts.
Of course, the revising the statement of facts, yes.
Okay. The motion to close, Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Aye.
Thank you. Thank you, Mr. Peru. This
Thank you.
concludes the public hearing for December 5th, 2022. We resume tomorrow with the rest of the calendar. Thank you.
All right. See you all tomorrow.